Right, good morning, everyone. I think we'll get started. My name is Ian Arby, and I am joint head of the Housing and Social Welfare team here at Doughty Street Chambers. And thank you so much for coming to our day-long seminar today about disability and housing law. Rather ambitiously, but hopefully not too ambitiously, entitled What We All Need to Know. And what we're going to try and do is we're going to try to look at how disability impacts upon the various aspects of housing law that we practice in, both public law, private law, damages claims, and as well as an opportunity for us to be able to talk to you. Hopefully it's an opportunity for us all to talk to each other and to have some shared learning. Now, there are going to be a number of panels, stroke sessions, and you will have the opportunity to ask questions at the end of each session, depending on how much time we have. Now, there's some very, very important points I've been asked to make. So firstly, Ray, who is there, and Camilla, who is not quite in the room at the moment, they'll be on either side of the room with handheld microphones during the question and answer session. And so if you would like to ask a question, please, if you just raise your hand and wait for the microphone to get to you. Otherwise, today is being recorded and the recording won't pick up your questions. So we are being recorded today, and so a copy of the recording will be available for you or any colleagues that are unable to attend if you get in touch with us afterwards. We haven't printed off slides or handouts in an effort to try to save paper. There is a QR code at the back there, and if you take a photo of that with your phone, you should get materials on that. And as I understand it, they'll be being added to during the day. And we're going to be taking pictures, apparently, throughout the day. And if you don't want to be photographed, just please let either Ray or Camilla know. There are PowerPoints at the side on the walls if you need to recharge your laptops or your any other computers. Please, if you need to do that, then do that in the break. The toilets are through the double doors on the right-hand side, and there's also a disabled toilet to the left of the waiting area. We're going to have 2 refreshment breaks as well as lunch. So one break in the morning, 1 break in the afternoon and lunch, and there'll be a drinks reception at the end of the day. Lunch, very, very important point, this is going to be served in room 4, and the evening drinks will also be in that, and the evening session evening session drinks will be in room 4, and then the drinks at the end will be in the seminar hall. There are no fire drills planned for today, so if there is a fire alarm, it's not a test. If the alarm does go off, please just make your way out of the building, and Ray and Camilla will be your fire wardens. If you're away from the room when the alarm sounds, then you make your way out of the building via the nearest fire escape route, which is indicated by signage. Then you report to one of us. And finally, if you wouldn't mind just putting your mobile phones to silent, that would be very kind. I always say that because I have to remind myself each time. So, moving on then, we are really delighted to have with us as our keynote speaker, Mr. Clive Gilbert, who sits beside me today. Clive is the Senior Policy and Research Manager for Assistive Accessible Technology at the cross-party think tank Policy Connect. And he's a member of a team which is involved with a cross-party group working to ensure that disabled people can benefit from technology and lead fulfilling lives. And in particular, he leads the team's work on social care and independent living. So I'm really pleased Clive is here, and I'm going to hand over to you, Clive. Good morning. Sorry, to just point out that Clive is...
Good morning, everyone. I'm the Senior Policy and Research Manager for Assistive and Accessible Technology at the cross-party think tank Policy Connect. I would like to thank Alice and the rest of the team behind today's event for inviting me to speak this morning about our work on independent living and widening access to assistive technology in the home. I will talk about our Smarter Homes for Independent Living report and its impact on the Disabled Facilities Grant. My talk will have three main parts. In the first part, I will tell you more about Policy Connect and our approach to shaping public policy by partnering with all-party parliamentary groups. As a former history undergraduate, I'm a stickler for the idea that understanding the past helps us understand the present. So in the second part of this presentation, I will put our recent work on smart home technology and the role it can play in the disabled facilities grant into context by looking at the history of the independent living movement. Thirdly, I will tell you about Policy Connect's cross-party smart homes and independent living commission and how it has shaped the latest update to government-issued guidance on the disabled facilities grant. While the primary audience for this work has been policymakers in central government, our ultimate goal is to ensure disabled people can choose how and where they wish to live in accordance with their needs and aspirations. Regardless of whether your work involves helping people to navigate the Disabled Facilities Grant, I hope my talk today will inspire you to consider how you can apply some of the ideas of the independent living movement to help your clients achieve greater choice and control in their lives. Policy Connect is a cross-party public policy think tank that specializes in running parliamentary groups and commissions. We are a social enterprise and are funded by a combination of regular annual membership subscriptions and time-limited partnerships from foundations, businesses, and universities. We work across a number of policy areas and industries, ranging from manufacturing and design to climate change. I am part of the accessibility team. Our team's work is divided into two areas: assistive and accessible technology and accessible transport. In the interests of time, I will limit myself to telling you about the former. The team was created in 2017 when Policy Connect helped to set up the all-party parliamentary group for assistive technology, a cross-party group for MPs and peers that share our interest in realizing the potential of technology to build a more inclusive society for disabled people. It is chaired by Barry Shearman MP and is supported by parliamentarians from across the political spectrum, from the former chair of the London 2012 Paralympic Games Organising Committee, the Conservative peer Lord Holmes, to the Shadow Minister for Arts, Heritage and Civil Society, Lillian Greenwood MP. We use the unique convening power of Parliament to bring disabled people into direct contact with policymakers, industry professionals, civil society, and other key stakeholders whose participation is vital to achieving genuine change. We do this through parliamentary roundtables, practical policy co-design workshops, and select committee-style panel discussions. We have had some significant success in helping government understand assistive technology and the ways in which it can be employed to transform disabled people's lives in the education system, the workplace, and of course at home. Our work on the Disabled Facilities Grant is an example of how effective our APPG has been in getting government policymakers to understand the benefits of assistive technology for disabled people and the communities in which they live. I will start to explain our work on the DFG, putting it into the context of the disability rights movement and the decades-long campaign fought by disabled people for the right to live independently. Independent living means the ability to control where and how one lives. It's been a key tenet of the disability rights movement for decades, but it has remained an elusive goal due to a lack of appropriate services and support. The campaign for the right to independent living stretches back to the 1950s and 1960s. Those years saw a generation of disabled students in the United States start to protest that their ability to participate in society was being held back by a combination of environmental and social factors and call for change. American universities, such as Berkeley and Illinois, led the way in encouraging students to be as independent as possible by physically adapting their premises and surrounding neighborhoods to make buildings more accessible for wheelchair users. By the 1970s, the independent living movement had spread to the UK, where disabled people demanded to escape from the institutional care settings in which many had previously resided for most of their lives and move into homes that they could truly call their own. Over the following 30 years, local authorities and central government were gradually persuaded to divert funding from care homes and cede control of the purse strings, so individuals could determine how it should be spent, rather than having to watch while others did so on their behalf. The key principle underpinning independent living is that services must be accessible to all and provided on the basis of equal opportunity to enable disabled people to enjoy choice and control over their daily lives. Independence at home is foundational to an individual's independence in other areas. One of the first fruits of the UK's disability rights movement was the 1970 Chronically Sick and Disabled Persons Act. For the first time, the Act made local authorities responsible for providing disabled people with welfare services, including adapting homes to meet their needs. This was one of the main legislative scaffolds on which the Disabled Facilities Grant was built when it was introduced 20 years later. I will now talk about our Smart Homes and Independent Living Commission and our work on the Disabled Facilities Grant. The purpose of the Commission was to make recommendations to government, local authorities, and the wider social care and technology sectors on how disabled and older people can use smart homes and similar technologies to lead healthy, independent, and socially rewarding domestic lives. The Commission was chaired by the former leader of Kent County Council Councillor Sir Paul Carter. It was guided by an expert steering group, including Liz Twist MP, leading academics in technology and social care, industry experts and people with lived experience. It was sponsored by Bournemouth University and Coventry University. Technology is becoming an increasingly powerful tool in the quest for greater independence. In particular, the emergence of smart technologies that integrate multiple devices inside and outside the home offer new opportunities for people with impairments to fine-tune mainstream and specialist assistive technology to meet their needs. The benefits of smart technologies for disabled and older people have a number of dimensions. One benefit is that they give users more control over their environment. Being able to control the lighting, window blinds, heating, and home alarm system through a single app on a smartphone or tablet puts people in charge of their homes in a way that was previously hard to envisage. It means the loss of control associated with disability and aging can be curtailed. Smart homes also help users to remain socially engaged. They provide access to the internet, news and entertainment platforms such as BBC iPlayer and Netflix. Personal photo collections and music can be made more readily available. Family, friends, and carers are all contactable at the press of a button or by voice command. Finally, smart technologies are increasingly important in the provision of social care. Products ranging from communication devices for people who might find it difficult to pick up a phone to emergency call systems, fall sensors, motion detectors, and other telemonitoring devices are allowing people to continue living at home for as long as possible, with a safety net should anything adverse happen. Our Commission asked how we can make it easier for disabled and older people to acquire and use technology to have greater choice and control over their lives. This might be with the help of a service provider or as a private consumer. We published our report Smarter Homes for Independent Living in the House of Lords in April 2022. We heard from frontline health and social care professionals, local service managers and commissioners, technology developers and suppliers, as well as disabled and older people and their carers. Pat, a respondent to our survey of disabled and older people, sums up many of our findings when recounting a visit from an occupational therapist before a hip replacement. They didn't seem to know much about smart gadgets and were amazed when I showed them mine in action, Pat said. Digital technology has yet to fundamentally change the way we support people to live independently. Many local authorities offer only the most basic support through telecare and assistive technology services, providing a narrow range of electronic aids. The Disabled Facilities Grant is an example of this outdated approach to technology in care and independent living services. Established in 1989, the Disabled Facilities Grant is a statutory program designed to help fund home adaptations and equipment for disabled and older people to help them live more independently and prevent or shorten stays in hospital. It is funded by central government and managed by local authorities. The Disabled Facilities Grant was originally conceived as part of a series of measures designed to improve the quality of the housing stock and is primarily designed to pay for capital costs associated with adapting the physical fabric of disabled and older people's homes. Grant awards always have tended to include independent living aids to help people make the most of their newly adapted living spaces. However, since the scheme's inception, the range of products and services that can achieve its aims have expanded significantly, but policies and practices that shape how the grant is applied have not evolved accordingly. In addition, efforts to modernize the grant, such as by introducing greater flexibility in the early 2000s, have not been exploited uniformly by local authorities across the country. There have been several calls for a more comprehensive reform in the scheme to bring it up to date with the latest technologies and therapeutic practices. Most notably, in 2018, a government-commissioned independent review recommended reforms to improve the way assistive technology is harnessed by the grant, including the creation of a new smart home starter kit for every applicant. The grant comes with delivery guidance from the Department for Levelling Up, Housing and Communities, which tells local authority professionals how to use it. This gets refreshed every decade or so to keep up with the latest practices. Our commission recommended that the government should include a section about assistive technology in its next update. So, we were delighted when the 2021 Adult Social Care Reform White Paper announced that the government would implement our proposal and put an assistive technology section in the forthcoming DFG delivery guidance. This is the first edition to have a chapter devoted to technology. The chapter is based on a briefing prepared by the Commission for the civil servants who were responsible for producing the new guidance. Its purpose is to help occupational therapists, social workers, housing officers and other staff involved in delivering the grant-use assistive technology to support people enjoy healthy, productive and dignified lives. The chapter points to several new technologies that fit neatly within its remit to help disabled and older people control sources of power, heat and light in their homes, including smart lighting that can be remotely turned on and off, dimmed or brightened, and made to change color. Smart thermostats that can self-adjust to the user's preferences and detect when they leave or enter the room. And infrared controlled power sockets to switch devices on and off with a remote control. Of course, not all homes feature the level of digital connectivity necessary for these devices to work effectively. The guidance confirms that the grant can be used to pay for infrastructure such as cabling, wireless routers, and Wi-Fi signal extenders. Another potential obstacle to using the Disabled Facilities Grant for assistive technology is that it is designed to pay for one-off capital costs. While it can easily fund the cost of installing equipment, it cannot underwrite ongoing maintenance or user support charges. The new chapter offers advice on how these costs can be managed, for example, by including a service plan as part of a grant award or sharing costs with other local and national public services, such as the Local Authorities Community Equipment Service and the NHS. The new guidance is a major milestone in the history of the Disabled Facilities Grant. It exists to empower practitioners to realize the potential of technology to creatively and holistically meet the needs of the people they serve. You can read the guidance on the Department for Levelling Up, Housing and Communities website. The guidance is still relatively new, and it remains to be seen what impact the assistive technology chapter will have on everyday practice. But we do know that practitioners are starting to take note and consider how they can include technology in disabled facilities grant awards to help enhance the independence of the people they support. In fact, Foundations, the national body that helps local authorities and home improvement agencies deliver the grant in England, has partnered with Taylor Wimpey and the Association of Residential Technology Providers, CEDIA, which is also a supporter of our APPG, to conduct a smart homes pilot program to understand the impact technology can have on the comfort, independence, and engagement of disabled and older residents. This could well lead to a larger national program aimed at supporting local authorities to provide more technology through the grant. That concludes my presentation. Thank you.
Well, thank you very much. That was really interesting to hear. And clearly, assistive technology is going to be increasingly important as time goes on. I know we're going to be speaking about the Disabled Facilities Grant this afternoon and adaptations. And I have to say, Clive, I'd always thought, whenever I think adaptations, I always think physical adaptations. So it's really interesting to actually think, no, that's not quite right, because there are all sorts of adaptations that can take place without making physical alterations to the dwelling. And so it's a question of the law catching up to where we are with technology. Does anyone have any questions? As I understand it, Clive, you're happy to take questions? Yeah. Okay. Well, thank you very much. I don't see any questions. Very informative and thorough talk. So it only remains for me to say thank you very much for being our keynote speaker. Thank you for speaking on such an important and developing area. And hopefully that's what today is all about. It's how we move forward with what we already have. And you've really provided a very thoughtful and interesting beginning to the day. So thank you very much for coming.
Thank you. Introductions. My name's Dominic Preston. We're dealing this morning with a panel session on mental health capacity. Some of you will know me as quite loud, so I was slightly disturbed when Ray just asked me to speak a little bit louder. Apologies to all if I start shouting. We have two speakers for you, Dan Clark and Sophie Miles, both barristers at Dowdy Street Chambers, both members of the Civil Justice Council working group that looked at the procedure for determining capacity in civil proceedings, so they should know their stuff. Sophie, many of you will know, I suspect some of you very well. She is a mental health and mental capacity specialist. She sits as a mental health tribunal judge and as a deputy judge in the Court of Protection. We have the benefit of her leading our Court of Protection and mental health team. She seems to find time for many other things. She's a contributor, author for LAG's Court of Protection Handbook. She is an immensely calm and intelligent figure. with a real ability to find practical solutions in complex cases. And if you think that's just spiel, it's not. When I'm in trouble, I ask. She may not be a housing specialist, but she is used to supporting the housing team as we stray into her field necessarily. Our laws, the laws we do are always overlapping. She helps us now as a barrister, and I suspect she helped others in the room formerly as a managing partner at Miles and Partners as well. And we're very privileged to have her here. Dan is much more familiar to all the housing lawyers here, I suspect. He has a broad practice in housing, social welfare and community care. Most of you will know him for his encyclopedic knowledge of housing law. His colleagues tap into that when they can. A strong practice in public law and human rights that includes, importantly for us today, an expertise in discrimination law. Often seen appearing in important cases in the higher courts, both for individuals but also for interveners. And as I mentioned earlier, he was deputy chair of the CJC working group on determining capacity in civil proceedings. I say that in the hope that that's the topic you'll start with. It may not be, but I'm going to turn to Dan and ask him to start for us.
Thank you very much, Dominic. So when we came to look at the topic of mental health and capacity in the context of housing and a housing conference, Sophie and I thought it would be helpful, rather than take you through by area of law, that we would approach this by way of looking at two common scenarios that housing lawyers tend to encounter, which often raise issues as to mental health and or capacity. And the two case study scenarios that we chose to look at are hoarding cases and antisocial behaviour. And so we'll take those two in turn, and for each of those we're going to look at issues arising in relation to possible defences to the claims, in particular involving mental health aspects, litigation capacity, subject matter capacity, as we've called it, and which can involve a number of different things, then potential sources of support for the client, and specifically the role of the Court of Protection. Sophie is going to broadly deal with the topics addressing capacity, so litigation capacity, subject matter capacity, and the role of the Court of Protection. And my role really will be as a support act in a session on capacity to set that in context of the housing law issues, and see how it all fits in. Because one of the things that I've certainly discovered over the years of doing cases which raise these issues is that as soon as you look at one part, you realise you need to look at the other part first, and then you have to look at the other part. And there's no easy way to set it all out in a straightforward line. And really, it's about the interconnection of areas, and that's hopefully what approaching it through these scenarios will allow us to do. So the first two slides, I've set out various key sources in relation to mental capacity, the Equality Act, the civil procedure rules, etc. I'm not going to go through all of those, but you've got them there for reference. So moving then to the first scenario, and just to set out some facts for the purposes of getting into the issues. We suppose you've got client X, who's an assured tenant of a housing association, who's been evicted from two previous properties on grounds of hoarding at those properties, and the GP has raised concerns about possible hoarding disorder. Problems have arisen again at the new property, and the housing association has brought possession claim under grounds 12, 13 and 14 under the 1988 Act. The housing association has made a referral to social services, who attempt to conduct a Care Act assessment, and X tells the social worker that he knows he's got too many possessions in the house and has to clear them or risks eviction, but says, I haven't got a hoarding disorder, and actually I'm in the process of sorting this out, so I don't need any assistance from social services, thank you. And that's, I imagine, if any of you have dealt with any cases of this type, a not uncommon scenario that you will have faced. So the first slide we've got here is thinking about possible defences, and I think the first thing I should say here, we were torn when we were coming up with the structure of this, whether to start with litigation capacity or defences, because in some ways, litigation capacity necessarily comes first, because until you've determined whether your client has got capacity to give you instructions, you don't know what defences you're able to run, because you're either going to be running defences based on your client's instructions or on the instructions of a litigation friend. But in an illustration at the outset of the way in which these issues can't decide on an order of priority, actually, in order to look at litigation capacity, you have to decide what are the issues that might arise in the case on which your client has to be able to understand information, weigh information, communicate decisions. So already you have a sense that, well, we can't work out what the defences are until we've got an idea about litigation capacity, but we can't get an idea about litigation capacity without knowing what the defences at least might be. So broadly speaking, in this kind of case, you've obviously got their discretionary grounds. So you've always got question of reasonableness and the court looking at all of the facts in that respect. You've also potentially got a defence on the basis of disability discrimination, that if the client does have a hoarding disorder and that amounts to disability, and if the hoarding, as one might think, arises in consequence of the hoarding disorder, then because the eviction is the eviction proceedings are being brought because of that, then prima facie you have a case of disability discrimination unless that can be justified. The first point I've raised under there, I mean, there's the usual questions about, is there a disability? Is there unfavourable treatment? Yes. And is that because of something arising in consequence of disability? But the very first question, as I've hinted at the beginning, is this consistent with your instructions from the client? And this is what's going to lead us to capacity, because as you've seen in the scenario at the beginning, the client is saying, I don't have a hoarding disorder, there's nothing wrong. So if your client has litigation capacity and those are your instructions, then there's no question about running a disability discrimination defence. If, on the other hand, it turns out your client doesn't have litigation capacity and you're getting instructions from a litigation friend, it may be that you have instructions to pursue that defence. The final bullet point there, and this really, it fits formally within the structure of a discrimination defence, but ultimately is going to be the same sort of questions the court's asking about reasonableness. Is there a more proportionate cause? Because whether or not you're looking under the framework of reasonableness or under the more structured analysis of disability discrimination, the court is ultimately going to be asking itself a practical question, which is there a way in which this tenant can continue to live at these premises, and the problem of hoarding, which no doubt the court and the landlord will be taking seriously as a health and safety risk, fire risk, etc. Is there a way that the tenant can continue living there without that problem continuing or occurring again in the future? And really, if the answer is no, then whichever way your defence is framed, you're probably not going to end up with the result of the client being allowed to stay there indefinitely. So really, there's a question about, is there some support that could be provided or changes made that would allow them to stay there? Or is it a case of saying, well, that doesn't look to be practical, we're going to need to look for alternative accommodation? And so the final point I've put on the slide is the idea of working inside and outside the possession proceedings. As I say, it's really ultimately a practical question about what can be done to ensure that this doesn't continue. And 90% of the time, if not 99% of the time, the answers really lie outside of possession proceedings or indeed the civil courts. It's not going to be an injunction. If you've got somebody who really has had these recurring problems, you're going to be looking towards community care support and or court protection. And that's where we're going to come in a moment. So with that, I'll hand over to Sophie to start on the question about capacity and in particular litigation capacity.
Thank you, Dan, and thank you, Dominic, for a very kind introduction and words. And it's really great to be here today. So I'm going to start by just going back to a couple of the sort of key principles in the Mental Capacity Act, key provisions in the Mental Capacity Act. And then we will look at how they might be applied in this case. And I think the first thing to say before I look at sort of the idea of people who lack capacity is it's always important, I think, to bear in mind the huge range of the Mental Capacity Act, because you just need to think about the number of decisions that you have to make during the course of every day of your lives in order to sort of get through the day. We're constantly making choices and we're constantly making decisions. And what the Mental Capacity Act does, in my view, is it provides a mechanism so that if there are some of those decisions you're not able to make because of an impairment or a disturbance in the function of your mind or brain, there is a mechanism for those decisions to be made for you. But the breadth of those decisions is huge, and we'll see that as we sort of work our way through this example. So the slide that we're looking at the moment just gives us a kind of reminder of Section 2 of the Mental Capacity Act, which explains what it means to lack capacity. So someone will lack capacity if they are unable to make a decision for themselves in relation to a matter. So that's already kind of highlighting the fact that you don't have a blanket lack of capacity. You may have a lack of capacity to make decisions about a particular matter. You may have the ability to make decisions about all other aspects of your life. So that's sort of it's very targeted on the specific decision that is being considered. And the lack of capacity has to be because of an impairment of or disturbance in the functioning of the mind or brain. And you'll see straight away, that doesn't say you've got to have a diagnosed disorder. You don't. You just need to be able to establish the presence of the impairment and the disturbance, and crucially, that it is the impairment or disturbance that is preventing the person from making the decision. Doesn't matter if that impairment is temporary or permanent. And, classic example is an unconscious patient who needs to be treated. That person clearly lacks, they're not able to make any decisions at all. They may be able to in an hour's time, but that might be too late. Can't be determined with reference to age or appearance or conditions or an aspect of the person which might lead others to make unjustified assumptions about capacity. So that's the sort of pointer to avoid discrimination in the way in which capacity assessments are approached, and the inability to make the decision has to be established on the balance of probabilities. And it will only bite, as it were, on people who are 16 or above. There is an exception where the court's making decisions about people's property and think that that person will lack capacity when they get to the age of 18. And an example of when that happens, a very typical example, is a child who has secured an award of damages, perhaps for injuries caused at birth. And the court it's clear that that child, when they get to 18, will not have capacity to manage the award, and deputies can be therefore appointed to manage it at an early stage. So that doesn't really, it sort of needn't really trouble us very much. So let's now go on and look at how we establish whether someone is able to make a decision or not. And this, I think, these tests are going to be familiar to everyone in the room. So P, and the Mental Capacity Act refers to a person who may lack capacity as P throughout the Act. P can't make a decision for himself or herself if they're either unable to understand the information relevant to the decision or unable to retain that information. Now, you don't have to, if you're able to retain information for a short period, you may still be able to make a capacitous decision, but you've got to be able to hold the information long enough to manage it, to keep it online, so that you can then carry out the third sort of part of the process of decision making, which is using or weighing the information as part of the process of making the decision. And you also have to be able to communicate the decision by any means. So it doesn't have to be by speech, it's, you know, sign language, writing, anything else. So let's just look at, just sort of unpacking that a little bit. I think the key thing to focus on is the importance of the information that's relevant to the decision. What on earth does that mean? What it includes information about the reasonably foreseeable consequences of making a choice or of making no decision at all. And if we look at the particular scenario of X, this might actually be quite relevant, mightn't it? We know that X is sort of saying, look, I know I'm sorting all this out. You know, it's all fine, nothing needs to happen. One might want to think about, does X realize the consequence of not making a decision at all about, for example, the disposal of property? So that's quite important, that, in conclusion. So I'm going to talk a little bit about litigation capacity, and I've just given you these all sort of very well-known references, and essentially, you know, the sort of key point in Masterman Lister is that to have capacity to conduct litigation, you've got to be capable of understanding, with the assistance of proper explanation from your legal advisors, the issues on which your consent or decision is likely to be necessary in the course of those proceedings. And as Dan has already kind of highlighted, in order for you to start even getting to that point, can X instruct me in these proceedings, you've got to have a pretty reasonable idea of what they're going to entail. What are the kind of issues that you're going to need instructions on? So I agree with the structure that you've put here, Dan, as we've started this off. And of course, as the case of Dunhill and Berg in the Supreme Court makes very clear, litigation can take all sorts of twists and turns. Something that looks like an extremely straightforward case at the start might become something quite different. And of course, a case in a case where someone is facing possession raises very different issues to, for example, a case about them in the Court of Protection, which raises all sorts of different issues about their own capacity, their own ability to make decisions for themselves. So you've always got to be thinking about, avoid the kind of idea of capacity in the abstract. It's absolutely linked to the specific decision, whether that's a decision about giving instructions over the course of a case, or whether it's a decision about where to live, or what care you want, or disposal of your property. So if we move on and look at what's called subject matter capacity, so we're looking at the specific decisions that X might need to make, and I'll come on to what those might be in a moment. But we've got guidance at the sort of very highest level from the Supreme Court in a case called a local authority and JB, and that's about what's the process that you take when you know that you've got to assess somebody's capacity. Well, Lord Stevens reminds everybody that capacity requires an ability to make a decision about a matter. So the first thing you've got to do is you've got to identify the correct formulation of what that matter is. What is the decision that this person needs to take that they may or may not be able to take? And then you've got to identify the information that's relevant to that decision. What are the reasonably foreseeable consequences if X continues to hoard? What are the reasonably foreseeable consequences if X continues to defer a decision about whether to accept help or whether to take any steps? And although I'm going to kind of give us some guidance from case law about what relevant information might include in particular cases, that information is just kind of pointers, and you're always going to be looking at the very specific factual context of this particular case and this particular person. So let's move on and look at what sort of guidance there is about various decisions that X might need to make. And the first thing we might want to think about is, well, does X have capacity to make decisions about disposal of some of the items that X doesn't need? So there've been quite a few cases in the Court of Protection where the court has had to consider, what does it mean to have capacity to make a decision to declutter, essentially? And the first case that looked at this is a case called AC and GC. And the judge sort of identified the following as sort of the sort of things that you've got to be able to understand, retain, and make a decision about. So what's the volume of the belongings that you've got? And what is the impact that volume has on the various rooms in the house? And that's going to depend on each individual room. So the impact of having your kitchen kind of piled high with newspapers, if you've got a gas cooker, might be different to the impact of having a box room that's full of newspapers, where nobody's actually going in, no one's trying to use it. So that's a pretty obvious kind of point. But this is perhaps a pointer to how kind of granular the approach is. You need to be able to understand about safe access and use. To what extent are you able safely to access and use living areas? And what about other residents in the property? You've also got to be able to understand about hazards, to the extent to which all those belongings are creating actual or potential hazards. And the safety of the building. To what extent could the structural integrity and the safety of the building itself be compromised? And then perhaps the most difficult one is that you have to be able to understand and retain and use away the fact that the removal or disposal of hazardous levels of belongings is possible or is desirable. So that's a particularly difficult one. If you have somebody who in fact does have a hoarding disorder, that's going to be very hard for them and that gives us an example of someone who you might have lack capacity in relation to disposal of items, but have capacity in many other areas of their lives. On to looking at other decisions that might arise here. So decisions about where to live. Again, we've got some guidance from a case called LBX and K, quite an old case, and that's guidance about what sort of information do you need to be thinking of if you're deciding where to live. So here we've got types of property, where is it? What's the difference between residing somewhere and living there? What sort of activities would be available there? And would you have to pay? What are the kind of consequences? And then decisions about care, again from the same case, what sort of areas do you need support with? Who provide it? And then perhaps the most difficult one, what would happen if you didn't have the support or you refuse the support? And also about carers may not always treat you properly and that you could complain. So that's just some of the guidance we've had about how you might assess decision-making capacity. And I'll hand back to Dan.
Thank you, Sophie. So I'm moving to look at the next of the bullet points that I set out at the beginning, which is about sources of support that might exist. So going back to the framework of possible defences that I set out, ultimately, as I say, whether you're looking under reasonableness or particularly under justification of potential discrimination, the court's going to be concerned about can this situation be addressed? And broadly speaking, there are two possible paths here. One being that it can be addressed by support provided at this property, and the other being that it can be addressed by moving X moving or being moved to alternative, more suitable accommodation. And the first possible route here is under the Care Act. And so quite typically, you might have a situation where either because X instructs you that they have a hoarding disorder and wants to run a defence on that basis, or perhaps more commonly because you've got a litigation friend giving you those instructions. You say, look, here is on the face of it disability discrimination, and the court has to be satisfied that there is no less drastic alternative than eviction. And you might be saying one alternative that's not been explored is support under the Care Act. And quite often what you'll be saying is, look, the court can't decide that Care Act support is not a viable option until there's been a proper lawful Care Act assessment and there's a care plan put in place or not. And we have to explore that first. So the possession proceedings, most often I find, tend to get paused, often for quite a long time under an adjournment or a stay, while alternative options are explored. Quite often you'll have the position, as we set out in the scenario at the beginning, where there's been a referral to social services attend, and either in the first instance, perhaps the client will have said, I'm all right, thanks, I don't want any help from social services, and social services go, fine, all right then, that's us, see you later. Often overlook Section 11 of the Care Act, which says that although generally a person can refuse assistance under the Care Act, where there's a refusal, the social services have to assess whether that person has capacity to refuse. Often, even if social services get to the stage of assessing capacity, a lot of the detail around how that should be done that Sophie's been discussing won't really be engaged with. There'll be a much more superficial attempt to ultimately, as we set out in the scenario, somebody who's saying, yes, I know there's a problem, but I'm sorting it. Social services will say, oh, well, they say that they know there's a problem and that's fine, therefore they have capacity, without assessing, in light of any potential hoarding disorder, does this person have the ability to weigh information, including about the desirability of disposing of possessions. So that's the first point at which you might have to have some engagement with social services. The second stage is that they'll often do an assessment of the client's needs for care and support and say, this person doesn't have eligible needs. And that is almost always because social services, I've found in these cases, tend to take a view which is entirely focused on physical abilities. So they'll look at the eligibility outcomes about ability to maintain nutrition or personal hygiene, for example, and say, effectively, this person is physically able to have a shower or to make a meal, and therefore there's no problem here. And in fact, actually, in cases of mental health problems, those issues aren't so obviously, or the connections to the eligibility outcomes aren't so often picked up. So you might have in this scenario somebody whose hoarding has got to the stage where, yes, they would be able to cook a meal in a kitchen which was free from clutter, but in fact they're not able to get to the stove anymore, or they're not able to get to the fridge, or the fridge is full of food that is decomposing, and so they're not able to maintain nutrition in that sense, or again that they're unable to access washing facilities, etc. Obviously, in these kind of cases, there'll be a question about whether somebody's able to maintain a habitable home environment, and there may also be questions about ability to make use of the home safely. As I've said, once it's been established that there's eligible needs for care and support, that care and support might be care and support to remain at the property, and typically in hoarding cases that might include a one-off home clearance, but also crucially regular support with cleaning the property, etc., or more less directly connected but still relevant support to access activities that mean that the person isn't spending their time going and accumulating further belongings. And often I've had cases where there are clients who, once they're assisted to access activities in the community, that goes a long way to addressing the issue which is ultimately causing some of the problems. Alternatively, if it's not possible to remain in the property, then it may be a route under the Care Act to more supported alternative accommodation. And I've put in there a excerpt from SB and Newham about the thresholds that has to be crossed in order for accommodation to be provided under the Care Act. The second aspect, so that's care and support. The second aspect that might be relevant under the Care Act is safeguarding. And I think this is, of the two, the one that's often overlooked, and certainly the one where the quality of analysis is very variable from social services, sometimes very good and sometimes much more formulaic. But section 42 says that where there is reasonable cause to suspect that an adult has needs for care and support and is experiencing or at risk of abuse or neglect, which crucially, as the code makes clear, includes self-neglect, for example, hoarding, and as a result of the needs for care and support is unable to protect themselves from that risk of abuse or neglect, then the local authority must make or cause to be made whatever inquiries it thinks necessary to enable it to decide whether any action should be taken in the adult's case, whether under this part or otherwise, and if so, what and by whom. So it doesn't really provide any defined substantive duties, but it potentially provides a helpful framework which should ensure that there's a coordination between the various agencies that might be able to provide useful support to address the needs here. And usefully also, there's a power under section 45 that where a safeguarding inquiry is being conducted, a local authority may require the provision of information, which particularly if you've got a client who is not wanting to engage with the process, might provide a way for relevant documentation to be obtained from third parties. So it's worth remembering the safeguarding provisions as a possible route to unblock some of the deadlocks and ensure that different agencies are talking to one another. So with that, I'll pass back to Sophie to address the role of the Court of Protection.
Thank you very much, Dan. I'm going to look at what the Court of Protection might be able to do in order to support X to remain at the property. And of course, for the Court of Protection even to be getting involved, there's got to be reason to believe that X lacks capacity to make the relevant decision. And there's got to be some sort of a dispute. So I mean, if everything's going swimmingly, X is offered a piece of support to declutter and is content to take it up, and there's a process of getting rid of the stuff and disposing of it, then that's absolutely all fine. But if the kind of cases that have come before the Court of Protection have been cases where all of that has been tried and it gets absolutely nowhere. I've been involved in a very, very long-running hoarding case where huge efforts made to support and help two people living in the property to declutter and repair it, all absolutely unsuccessful. We've got a couple examples of sort of similar sets of circumstances, both in the AC and GC case I referred to recently, and also in a more recent case called a local authority and X. So in both of those cases, what the court was asked to approve was an order that set out exactly what was going to happen to clear the property in a great deal of detail. So there was a full plan. How is this going to be done? First of all, where is the tenant going to be? Do they have to move out? Is it possible for them to remain on site while all this is happening? Which room is going to be cleared first? Who's going to do it? How is the decision going to be made about what is going to be retained? What's going to be stored? So that's the kind of plan that was approved in those two cases. And in order, of course, for the court to approve that, the court had to be satisfied that it was in the best interests of the people concerned. And the case of local authority in X in particular, it was a case where the court had to give really sort of careful scrutiny to the risks to X, because there was a real potential that the removal of her items would actually tip her into a suicidal state. So it's a very interesting judgment to read, all those issues being carefully weighed up. The other aspect of these cases, and again, certainly from my experience, has made quite a big difference, is the role of specialist providers who will go through the process of declutter and offer kind of quite therapeutic support to the person to make it easier for them. And all of these are things that have formed part of plans that the Court of Protection has been willing to approve. Now, if for whatever reason it's felt that that is not in X's best interest, or it's just impossible for some reason, of course, the court can also make decisions about X moving to alternative accommodation. That requires the identification of the alternatives. Court of Protections can only choose between available options. That's the case of N and a CCG in the Supreme Court. So what is the local authority actually going to be willing to commission for X? What are X's wishes and feelings? The Court of Protection will give those a good deal of weight, and that will vary depending on the circumstances. But of course, those wishes and feelings are not determinative, and the courts have made decisions about people being removed from their homes and moved into alternative accommodation, even when that has not been in accordance with their wishes. But in order to make all this happen, of course, someone has got to make an application to the Court of Protection. So usually that will be the local authority. One would expect that to be the local authority. It may not be that easy to persuade them to do so. In some circumstances, it might be possible to make an application in X's name if you had a potential litigation friend. I've listed the various forms that need to be lodged with as part of the application to the Court of Protection, and that includes somebody carrying out an assessment of capacity. And if you've got someone who's kind of barricading themselves away and not wanting to engage, that can itself be quite difficult and quite a challenge. And then there's going to then be a consideration at the early stages as to how that X is going to participate in the process. Does X have litigation capacity? If they don't, then there will need to be consideration of litigation friend, potentially accredited legal representative. And I've just flagged there as the last item is just practice direction 3B, worth looking at that if you're ever finding your way in the Court of Protection, because that sets out a sort of really clear roadmap as to all the various different stages the court is going to go through and what they expect at each stage. And I will hand back to Dan.
Thank you, Sophie. I'm going to come on in a second to introduce the second scenario that we're looking at, but just a couple of points. Dominic points out very helpfully, it's also worth bearing in mind that the landlord can make an application to the Court of Protection. So that was just one point that Dominic wanted to add. But tying it back to the initial structure that we were looking at about where this fits within the housing case, you will have seen from Sophie's slides that the Court of Protection has a very, I think, detailed, nuanced and appropriate way of looking at the circumstances, in contrast, I think, to the position that the civil court finds itself in possession, because ultimately the civil court is deciding whether or not there's going to be a possession order and potentially how long it's going to be, whether it's going to be suspended on terms. But really its choice is eviction or no eviction. And it seems to me that in a lot of these cases, even where you've got a situation where it looks like X can't stay at the property, there is still, I would say, a question about the proportionality of how everyone proceeds from there. Because if X is going to have to leave, there are two ways of that happening. One is that the civil court makes an order, evicts X, and then everybody scrambles around in a situation of emergency. And the other is that the case goes to the Court of Protection. It's determined that it's not in X's interest to remain in the property. Alternatives are found, perhaps through the Care Act or whatever it might be, and the Court of Protection approves that plan, and that move is effected in a kind of structured way. And it seems to me that it's often, if not always, worth arguing in the possession claim that even if you get to the stage where X can't stay at the property, the court still has to consider whether it's proportionate for the landlord to push on for an order to evict, or whether the more proportionate course in those circumstances is for the matter to be stayed while things are dealt with in a kind of structured and more sensitive way in the court protection. So that's just my concluding thought on that. Sophie having shown us a lot of the ways in which the court protection can help in a more considered way. So moving then to the second scenario, and we'll deal with this more quickly because I think we can just highlight the areas where different issues arise. The scenario we set out is in relation to antisocial behaviour. So why, being a secure tenant of a local authority, a history of mental health problems, including admissions to hospital under the Mental Health Act following episodes of psychosis, also a history of alcohol dependency. Why begins harassing and threatening neighbours when drunk, accusing them of spying on him on behalf of MI5, and the local authority obtains a without notice interim injunction with a power of arrest under the 2014 Act, and then also issues a possession claim under grounds 1 and 2 under the 1985 Act. So defences, again, reasonableness, again, discrimination, possibly on the disability discrimination under Section 15, which raises similar issues to scenario 1 about is there a disability, is the unfavourable treatment arising because of something arising in consequence. A couple of points to flag here. First, remember the Equality Act 2010 disability regulations, which exclude certain impairments from the definition of disability, and relevantly here, addiction to alcohol, and also tendency to physical abuse of other persons. And it's not specified in the scenario, but sometimes you'll have cases where somebody who very clearly does have a disability, and as a result of that, as a result of their condition, perhaps has ended up assaulting somebody, but you wouldn't be able to run a disability discrimination defence in that case because of Regulation 4.1c. Having said that, very useful case, which I always end up coming back to, Risby and Waltham Forest, deals with the nature of the causal link required, and it's necessary that the disability is an effective cause of the reason for the unfavourable treatment, but it need not be the sole or even the main cause. So you might have a situation where the local authority is bringing a claim for possession on the basis of a number of incidents, one of which is excluded from the definition of disability, but others aren't. And then you might be able to say, well, look, the stuff that's not excluded is still an effective cause, and so we're still within the scope of Section 15. Although, as I said in the final bullet point, where you're in a situation where you're completely excluded, then you might need to look at discrimination arguments under Article 14 with Article 8, which aren't subject to the same restrictions. So passing over to Sophie then in relation to litigation capacity in this scenario.
Yes, I mean, not very much to say really. It's you use the same approach as we discussed earlier on with the authorities that I put up at the slide, and it requires Y to have capacity to conduct this specific litigation. So you would just be looking ahead. What are the issues? What are the areas where Y is going to need to give me instructions? I think that's really all I need to say about that, Dan. So back to you.
Good. So here's my small section of the headline slot, because I get to deal with a capacity topic, which is injunction capacity. So I said in the scenario that the local authority has obtained a without notice injunction with power of arrest against the client, which is unfortunately not at all an uncommon situation, even where the local authority knows that there are mental health issues and maybe capacity issues. In relation to injunctions, you'll all be familiar with the case of Wookey and Wookey, which says that an injunction shouldn't be granted against a person who's incapable of understanding that what he is doing, incapable of understanding what he is doing or that it is wrong. And in addition, the case of Pender and DPP is helpful. That's an old antisocial behaviour order case, but that says even where the client can understand what they're doing, but is unable to comply, and that may be the case where you have somebody with very serious mental health problems who can kind of understand in a rational sense that there is this injunction, they mustn't do these things, but in the moment of any given situation is unable to prevent themselves from acting in that way, then Pender is helpful there. As I said in the final bullet point, there's a significant concern that I have, and not only I have, about the use of interim injunctions, particularly with powers of arrest, in cases where there's a suspicion that somebody might lack capacity. And that's a concern that was raised in the Civil Justice Council's 2020 report on antisocial behaviour in the civil courts, and is in fact the subject of some ongoing litigation, MTA, which I'm involved in with Martin Westgate in the team in Chambers, in a case where, in effect, an injunction was made against somebody where there was a suspicion they might lack capacity. It was ultimately discovered that they did lack capacity, and so the injunction was of no effect. But what was of effect was the fact that he'd already been arrested 3 times under the power of arrest, and so it's not very good at that stage saying, oh well, none of this has any effect, when in fact it has done. And so that is also the question of interim orders is something that the current Civil Justice Council working group on mental capacity is looking at. So, Sophie, on subject matter.
Again, quite briefly, so we'd be looking at whether Y is unable to make sort of specific decisions because of an impairment or disturbance in the function of the mind or brain. And I mean, if in the event that Y is driven by a psychotic belief that he is being spied on and that neighbours are being carrying out these spying activities on him, then in that situation one can see that the impairment of the function of the mind or brain may be impacting on his decision making. I mean, again, we've looked already at what you might need to consider if you're thinking about, does Y have capacity to decide where to live? Is he so overwhelmed by these psychotic beliefs that he can't, he can't make a decision about where he should be, or he can't make a decision about the care that he needs? I've just flagged here some guidance as well on capacity to enter into or surrender a tenancy. And these are from a case called Lewisham and QR, and it's a district judge case, so it's not binding, but it's actually quite a well-known case. So that just sort of identifies the kind of things you might be considering. And I guess perhaps what relevant here is the obligations that the consequences to Y if obligations under the tenancy are breached. If Y was just unable to understand those because he couldn't get past the sort of psychotic belief that people are spying on him, that might affect his capacity. So that's all I wanted to say about that. Back to you, Dan.
So moving then to support from other sources, the first place that I'm looking is again the Care Act, and really the issues will largely mirror those that I looked at in scenario 1. 2 strands potentially. One is the support that can be offered to help Y remain at this property without the issues recurring. And on that, in fact, if you're probably familiar with it already, but the case of Stevenson and Birmingham, there's quite a helpful discussion there about the kinds of alternatives that might be more proportionate than an eviction, and some of those might be matters which interact with Care Act support, or alternatively whether it's necessary for Y to move to some alternative, perhaps more supported accommodation. One thing to note in relation to eligibility criteria, it seems to me in this scenario there's a question about developing and maintaining family or other personal relationships, and often social services will just kind of skip over this or say something brief about Y's relationship with his family. But obviously other personal relationships may include relationships with neighbours, or more widely. And so that's something that should really be considered in the context of this scenario. Similarly, maintaining a habitable home environment. Again, social services tend to look at this very much in terms of the physical, but the statutory guidance, paragraph 106F, says that an adult may require support to sustain their occupancy of the home. And so in this case, clearly, if Y needs support to stop causing antisocial behaviour in order not to be evicted, then I would suggest that Y needs support to sustain the occupancy of their home, and so that should fall within that eligibility outcome. The other source of support that might be relevant here, given Y's history of admissions under the Mental Health Act, is Section 117 aftercare. This applies where a person has been detained under Section 3 of the Mental Health Act, but not where they've just been detained for a short period under Section 2. There's a duty on what used to be CCGs, but is now integrated care boards, and so in effect the NHS, the relevant NHS body, and the local authority jointly, to provide or arrange for the provision of, in cooperation with relevant voluntary agencies, aftercare services for any person to whom this section applies, until such time as satisfied that the person is no longer in need of such service. Relevantly, they're not able to charge for aftercare services, so that's something to bear in mind. An assessment for Section 117 aftercare is governed by the framework for NHS continuing care. It's worth noting that following previous relatively restrictive case law, the Section 117(6) was amended by the Care Act to, for the first time, define what aftercare services are. And that's services which have both of the following purposes: meeting a need arising from or related to the person's mental disorder, and reducing the risk of a deterioration of the person's mental condition, and accordingly reducing the risk of requiring admission for treatment for a mental disorder. There's a helpful section in the Mental Health Act Code of Practice which talks about local authorities and ICBs treating the definition broadly. And there's parliamentary material. I think if you look in the textbooks that I referred to in the first slides, which suggest that this was very much intended to be a broadening of the definition, particularly all related to. And so, as with the Care Act, I mean, the cases tend to deal with whether or not accommodation can be provided, and a general rule that mere accommodation can't be provided, but some kind of supported accommodation can. So again, this might be a route to either support the property or more supported alternative accommodation.
And finally, on the role of the Court of Protection in this type of case, again, I sort of wonder if this is the kind of case that's actually that likely to end up in the Court of Protection, really. But it's if we identify the kind that the matter, it might be, you know, what is Y's best interest as to where he resides or what care he gets, and of course that's going to require him there to be reason to believe he lacks capacity to make that decision. It's just worth bearing in mind that, again, since the local authority and JB, that's made it clear that when we're looking at the relevant information and the reasonably foreseeable consequences, those include the reasonably foreseeable consequences not just to P, but to other people as well. So that has brought into the scope of people who may lack capacity those who can't understand the impact of their behaviours on others. And therefore quite a lot more people who perhaps otherwise might be being dealt with, you know, through kind of forensic processes, are now having cases heard in the Court of Protection. Theoretically, the court could decide that, you know, Y lacks capacity to decide what care they need, because one of the reasons might be that they can't understand the consequence of their behaviour on other people. Potentially, the court could authorise a more restrictive care package to prevent that, but that's pretty fact sensitive and pretty, you know, that's pretty heavy duty in the Court of Protection. I think it's just worth mentioning in terms of the Section 117 as well. Section 1 of the Mental Health Act makes it clear that dependence on alcohol or drugs is not considered to be a mental disorder, and it's very difficult sometimes to disentangle the impact on people's behaviour and their conduct of a genuine disorder that is really, disabling their ability to make decisions or to control themselves, and the fact that they've simply gone out and had too much to drink. So those, this is a tricky case, I think, on any view. Thank you. That's all I wanted to say.
Well, thanks to Sophie and Dan, to both of them, for giving us quite a few tools to think about. We've got time for questions, and if you don't have any, I do, so beware. I suggest you put your hands up and avoid me speaking. The first hand I saw is at the back, about 4th row up.
So I have a question about the definition of care and support. Is it the same as the eligibility criteria for support under Section 13? So I'm thinking about Section 42. Is that the same definition, or is it slightly lower threshold? And then just while you were talking about your different examples, capacity issues often come up in homelessness cases as well, where you can get I've got an independent psychiatrist to say he lacks capacity for a potential JR regarding the Care Act issues, which is a Care Act JR. But then we don't want to make that point in relation to the Part 7 application, because then they can't make a homelessness application, and neither the housing department or adult social services then help him with accommodation. So it's just any kind of ideas for strategies on those kind of cases.
So in relation to the first question, the definition of care and support under Section 42, I think the point to make there is, in fact, the definition, the eligibility regulations don't define the scope of care and support even under Section 9, and that's the way that local authorities generally approach it. They just look at the eligibility. Those are the relevant needs for care and support, and so everything else is ignored. Actually, I think if you look at the structure of the Act, an assessment of needs for care and support should, in theory, be much broader than needs which are directly tied to the eligibility criteria. And it's just that you then have to go to the eligibility criteria to see whether those needs are going to be met. So yeah, absolutely. I think that needs for care and support, both under Section 9 and under Section 42, can be much wider than the needs which would fulfill the eligibility criteria. In relation to the question of capacity on a homelessness application, I think we've been left in a very difficult position by the decision in WB. It's not a terribly practical approach that the court took, in essence saying that somebody without capacity to enter into a tenancy can't make a homelessness application. I have to say, I'm not sure that should necessarily be the case, but it's where we are. That being the case, exactly how to deal with it in a particular case is going to be difficult. I'm not sure it's the case that under the Care Act there couldn't be some emergency provision made. But yeah, certainly it would be much cleaner if you could just make an application on behalf of under Part 7 on behalf of somebody who lacked capacity to enter into a tenancy, and deal with that lack of capacity at the point when they needed to enter into a tenancy. But yeah, unfortunately, that's not where we are. And so, I don't know, Sophie will know much better than me how able the COP is to deal with things very urgently. I'm not sure I've ever heard of a case where somebody's managed to get very urgently into the Court of Protection to have somebody appointed to make a homelessness application on that kind of timescale of urgency.
Actually, the court can work incredibly quickly, so it's worth thinking about that. I suppose the other thing just to bear in mind is that you are talking about two different decisions. One, I think, is a decision about care and understanding a need for care and support, which requires you to understand, what would happen to me if I didn't accept this care and support. So it requires quite a bit of sort of insight into your needs and so forth. And the other is, do I want to make a housing application? I suppose, and can I manage the tenancy? So they are different. Wouldn't be impossible to come to two different conclusions.
Any other questions? I'm going to take one from the front. But whichever is easier for the microphone, frankly.
Thank you. So, as you probably know, the UN Convention on the Rights of Persons with Disabilities forbids any sort of substituted decision-making, which is obviously very much the state of our law under the MCA, and instead recommends supported decision-making when possible. I was wondering if there was, what potential avenues there are in order to protect the rights of the disabled people are working with, to try and find supported decision-making processes before resorting to the frameworks which are in violation of disabled people's rights, if that makes sense.
So section
Yes.
2 not compliant?
Well, I mean, no, strictly speaking, it wouldn't be. No, I think that's absolutely right. I mean, if you strictly apply the CRPD, then the Mental Health Act and the Mental Capacity Act are very problematic. I think that what possibly kind of mitigates that is some of the principles around the Mental Capacity Act about the importance of not treating someone as lacking capacity until you've made every possible effort, reasonably practicable steps to get them to take the decision themselves. So that sort of supported decision making is very much embedded in the Act before you resort to making declarations that someone lacks capacity.
Yeah, no, I was just wondering, practically what avenues.
Well, I suppose practically what you'd be saying to, a local authority is saying, well, you've got to look at this principle of the Mental Capacity Act, and what are the reasonable steps that you've taken in order to do that? And you might challenge an application in the Court of Protection on the basis that those reasonably practicable steps haven't been taken.
I think while the microphone travels across, I'm going to ask Dan a quick question. So if you take the microphone over to Sarah, please. Dan, you mentioned, and part of your talk is a lot about finding resources which solve the practical problem underneath. In your experience, what's the degree to which those resources come, maybe not from the local authority, maybe not from others, but from the landlord themselves, where that's, for instance, not a local authority, but a housing association or even a private landlord?
My experience is really that in practice it varies a huge amount depending on the landlord, and in fact depending on the particular housing officers who are involved, in combination with whoever might be involved from social services or mental health social workers, etc. There are certainly cases where landlords have been very amenable to funding support to deal with issues and taking creative approaches, and then there are other cases where landlords have taken a much more closed-minded approach and said, look, here are the terms of your tenancy, you're breaching them, it's up to you to sort this out, and much more of the legwork is having to be done outside. So it's certainly worth looking at policies of landlords, seeing if you can engage with them, because that's generally going to be the most favourable and sustainable solution if it's possible.
And the degree to which courts can persuade landlords by reminding them of the risk of dismissal if they haven't pursued a proportional alternative.
I mean, similarly, it depends on the judge, I think, and obviously, what we should be doing as legal representatives is guiding the court towards that position, guiding the landlord towards that position, and in some cases, that will work, and in some cases, it will be less of a possibility. But certainly, it's an approach to bear in mind and to try and guide things towards.
Sarah, do you have a microphone at all?
Yes. Dan, you mentioned hoarding cases where people had been assisted by having community activities. Can you expand on that bit? What kind of community activities were helpful?
It's actually, I have to cast my mind back sometimes. These are cases that I was involved in quite a long time ago, and really, it depends very much on the individual case. It's not activities that have any direct relationship to issues of hoarding at all. It's where where I've had clients who want to get involved in, I mean, I really can't remember the details of it, but and if, you know, activities in the community. I mean, I've had a few cases where there were problems with clients hoarding at a property where they haven't had much engagement with external social networks or activities, which mean that a lot of their time is spent at home or going out and accumulating possessions. And actually, where they've wanted to engage in a kind of adult learning course or whatever it might be, but need some help to be able to kind of access that in one way or another, those are the kinds of things which then, you know, give them an alternative focus and you know, not on its own, but have been helpful in terms of addressing the underlying issues.
Any other questions? Since the microphone is so close.
I just wanted to ask about the role of the Court of Protection. Often, if you're dealing with a litigation friend, they're having to make loads of really important decisions for someone all the time. When would you go to the Court of Protection? What kind of decisions would have to be made there instead of a litigation friend making them for the person?
So what sort of decisions might the litigation friend have to make?
More what decisions are of such importance that it should be the Court of Protection that are making those decisions instead of the litigation friend?
Well, the litigation, yes. So, okay, I think I see what you're asking. So the litigation friend would be once they're appointed, and they're only obviously going to be appointed once you've got a live case in the Court of Protection. The kind of case law states that litigation friend is really responsible for the case management decisions. So and in particular how the person participates in the proceedings. That's very much seen as the litigation friend's responsibility, and the litigation friend might make decisions about, you know, applying for expert evidence and so forth. They're still supposed to be, you know, in the course of the litigation, you've got a duty to promote your client's participation and as far as they're and give effect to their wishes and feelings as far as they're able to express them. But when it comes to substantive decisions, the litigation friend's got no sort of powers at all. So the litigation friend might decide not to oppose an application, but it would still be the court that, you know, for the person to be moved from their home, for example. But the court would actually make that decision. Is that what you're sort of getting
Absolutely,
at?
Yeah, thank you.
I think we're running out of time. I'm going to bring matters to a close. Before I do so, I'm a very old person. Does anybody here remember the case of Romano at all? That was the first case in which the Disability Discrimination Act was used almost 25 years ago as a defence in possession proceedings. And the distance we have travelled, and indeed listening to Clive this morning, and the distance in the sense that he has travelled or that his area has travelled is enormous. And I think we all recognise that, but we also recognise how much further there is to go. I think there has been a sea change in the county courts. I think local authorities, for all their lack of resources, do try where they can. But I think what we still need, and what I think Dan and Sophie have shown us, is the tools we need to show what that proportionate alternative is and why somebody cannot have that possession order that they're looking for, and how a bit of imagination, a bit of thought and a bit of resource from others can be used to find an alternative solution for our clients. And I hope that that has come across today. It's certainly, even though I am long in the tooth, inspiring for me, and I'm grateful to them for all that they've told us today. So if you don't mind, thanks to them for their time, and thank you for putting up with us as well for 45 minutes. Thank you very much.
Thank you, Dominic.
Thanks, everybody. Hope you had a good refreshment break. This is going to be our session about Equality Act and damages. So looking at the best ways to get the best sort of financial outcomes in lots of cases where it sometimes feels like damages is more of an afterthought or a strategic method rather than an actual aim in itself. So we are very lucky to have Ria Murray here, who joined us, I think we just worked out almost exactly a year ago. So she has a broad housing and homelessness practice with specialisms, especially in the Equality Act and eligibility. And we've got Sarah Steinhardt here, who's the guru of all things Equality Act. That was a bit cheesy, but it is true. So Sarah has lots of really high profile Equality Act cases. She used to work in employment as well, so she draws a lot of knowledge from the employment tribunal field and when she's asking for damages in the Equality Act. And she has a specialism now in special educational needs and broad disability law. So without further ado, Ria's going to take us through the bones of the Equality Act.
Thanks. So I'll introduce the structure of the Act and make some points about starting claims under the Act. I'll talk briefly about different spheres of activity. So for our purposes here, it's usually going to be part 3 or part 4 that we're bringing claims under. And I'll talk briefly about contraventions of the Act as well. So I think it's fair to say the Act is long and it's extensive and lots of details hidden in the schedules. So if you are going to bring a case under the Equality Act, you need to look at the schedules and what they say specifically about the facts of your case and how you're going to need to plead your case. There's very helpful statutory guidance. It is compulsory. If you're bringing a claim under part 3, the services and public functions guidance is the one that you'll want to look at. If you're at the stage of defining what is a disability, the guidance, that's the second bullet point there, is very helpful. It's got lots of practical examples which really help you to think through how you're going to put your case from the start. So the protected characteristics are given by section 4 of the Act, and we're going to be looking mainly at section 6. So section 6, you can see the disability, the definition of a disability there on the slide. Just 1 or 2 points to make about it. An impairment is not necessarily going to be something that's diagnosed or clinically recognised as a disorder. It must be more than minor or trivial. We know that from section 212. In terms of a long-term adverse effect, what you're usually going to be looking at is more than 12 months, but it's worth looking at Schedule 1, paragraph 2. And it's in respect of normal day-to-day activities. Schedule 1 also provides for some deemed disabilities by paragraph 7, so that's the certified blind, sight impaired, or partially sighted, certified by a consultant ophthalmologist. We get that from the disability regulations, so those provide at regulation 7 for deemed disabilities. So just 2 further points to make about impairments. There was an EAT case where the EAT held that there's a valid distinction to be drawn between a normal reaction to an adverse life event and something that develops into an impairment over time. So the EAT upheld the ET's finding that the claimant had not been suffering from impairment, noting in some cases bereavement may lead to ordinary symptoms of grief that do not bespeak any impairment. In others, it may lead to something more profound, which develops into an impairment over time. The second case to consider is on the slide there, it's the case of Walker. On appeal there to the EAT, the President held that the tribunal was in error in concluding that because there was no physical or mental cause that could be identified, there was no disability. The judge should have regard to the effects of the impairments, not their cause. And then he said, I accept that the mental and physical overlap. The purpose of the definition of disability is not to confine an impairment to that which can be shown to be given a medical label, which is either a recognised or physical mental condition. It's rather to describe the nature of the impairment. So the message overall is that disability is a functional assessment. You don't necessarily need to have expert evidence or a report in order to conclude that somebody has a disability. There are some excluded conditions. So the disability regulations 2010, which I mentioned, regulation 4 excludes things like tendency to set fires, to steal, physical or sexually abuse others, and exhibitionism and voyeurism. The regulations also exclude addictions of regulation 3. So there are a couple of final observations to make about defining an impairment. So I'd make 3 observations. Firstly, when you look at the guidance, you're directed to consider the cumulative effects of impairments together overall on a person's ability, and that's at the disability guidance at paragraph B6. The effects of behaviour, what reasonably they do to manage in terms of coping strategies. And it would not be reasonable to conclude that a person who employed, say, an avoidance strategy out of pain or fatigue or to avoid something like social embarrassment was not a disabled person. That's at paragraph B9. And similarly, the strategy breaking down is something that you must take into account. That's a paragraph B10. The first schedule, Schedule 1, paragraph 5, tells us that the effects of medication must be excluded. The guidance echoes this at B12 and B13. So even if completely controlled, even if the medication completely controls the condition, you treat it as if it's not in place. Cures and past conditions are also something which is addressed in the guidance at B17. And thirdly, the cause of the impairment is irrelevant. The guidance is also really helpful on this. It gives some really good examples. So I think it's A7 of the guidance. It's not necessary to consider how an impairment is caused, even if the cause is a consequence of a condition which is excluded. For example, liver disease as a result of alcohol dependency would count as an impairment, although an addiction to alcohol itself is expressly excluded from the scope of the definition of a disability under the Act. What's important is to consider the effect, not the cause. See the reference on the slide to guide A7. In terms of providing evidence, I'll probably leave the practicalities of that to Sarah. And move on to the spheres of activity. So for our purposes, as I said, it will usually be part 3 or part 4. They are designed, it seems, to avoid overlap. Part 4 being concerned then with premises. Premises are not considered to fall within the definition of goods, facilities or services. Those come under part 3. And it's fair to say that part 4 is heavy going and there's no code of guidance. In general, it's concerned with sale, leasing and management of residential and commercial premises. And premises is the whole or the part. So we get that from section 38(2). So I'll explain how part 4 is structured very briefly, and then I'll mention 2 cases. So it's structured as follows. Essentially, there's a prohibition on discrimination in the disposal or management of premises. We get that from sections 33, section 34, and section 35. There's also a duty to make reasonable adjustments on controllers of let or to let premises and common parts, section 36. The scope is restricted. So age and whether someone's married or in a civil partnership, those are excluded matters. Also, the part provides right at the start of part 4 that if your claim can come under work or education, you should bring it under those parts of the Act, not under part 4. So short stay accommodation is excluded, and so is accommodation, the provision of which is for the purpose only of exercising a public function or providing a service to the public or a section of the public. We get that from section 32(3). For our purpose, the key issue is usually going to be disposing, which includes letting, creating a subtenancy, assignment, and parting with possession. So disposals, section 33. This could potentially include an allocation of housing, but those sorts of cases are usually brought by judicial review. And they're usually approached under the service provision. So there are 3 cases on the slide which are examples of that. Certainly in Z at first instance, the allocation was a service provision. So So there's always going to be a bit of a debate about whether you're bringing your case into part 3 or part 4, but again, I'll leave that to Sarah. Harassment and victimization are expressly prohibited under part 4. So harassment is prohibited by section 33.3. Religion and sexual orientation are excluded, section 33.6. But this conduct on facts in that scenario is going to amount to a detriment. So you're going to argue that it's a detriment for the purpose of direct discrimination, and you can bring your claim that way. So it's not particularly consequential that those are excluded under this section. Victimization is also specifically prohibited under the part. There are some explanatory notes because part 4 isn't easy to understand. The explanatory notes to the Act aren't legally binding, but they do give some concrete examples, so it does help for you to understand quite what's meant. Explanatory notes at paragraph 134, for instance, explain how permission might work. So, for instance, a disabled tenant wants permission to sublet a room to help pay their rent and is refused because they're disabled. That would be unlawful. Management is not defined. It's suggested that it would include estate agents, rent collection agents, TMOs, managing agents. So 2 cases on this. Firstly, there was a county court decision in Plummer and Royal Herbert freehold. The proprietor of a flat was refused reasonable adjustment, which he wanted to the leisure centre. The leisure centre was a communal facility within the block. He argued that the provision of the leisure centre was a service. In fact, he brought it that way. And he argued indirect discrimination in the works that were agreed to be carried out. He got an award of £9,000 of damage, £9,000 damages for injury to feeling. So that stands out particularly as a fairly high award. In fact, probably the highest I think I know of for that type of case. And then the other case, which I'd like to mention, I think everybody will be familiar with, is Ackerman Livingston, at the bottom of the slide there. So Ackerman Livingston was essentially concerned with how much more protective, how much stronger a defence to possession based on proportionality was going to be when it was brought under Section 15 of the Equality Act, as compared to an Article 8 proportionality defence to possession. So that was the main issue at the time. But Lady Hale's judgment is very helpful and does address causality and proportionality, the shift in the burden of proof, and discusses when Equality Act defences can be summarily decided, which is very narrow set of circumstances. That's at paragraph 36 and 60 of her judgment. What's really helpful to take away from that is the court emphasised the causal relationship, which must be found for Section 15 disability, the causal relationship between the disability and the discriminatory treatment. So the other thing I mentioned under part 4 that's important is Section 36, the duty to make reasonable adjustments. It functions a bit differently under part 4 compared to part 3. I'm not going to go into an awful lot of detail about it, but it is more limited under part 4. So part 3 is the services and public functions part. Again, it opens with Section 28, which is application of this part. Plainly, there's an intention to avoid overlap. So it opens by saying at 28.2, this part does not apply to discrimination, harassment, or victimization that's prohibited by part 4 premises. So there's a distinction there. Section 29 prohibits discrimination, harassment, and victimization in the provision of a service, and a duty to make reasonable adjustments applies to service providers and those exercising a public function. A key difference is going to be reasonable adjustments. the code is helpful here. The services code provides at 721, service providers should therefore not wait until a disabled person wants to use a service that they provide before they give consideration to their duty to make reasonable adjustments. They should anticipate the requirements of disabled people. So it's an anticipatory duty. I won't say more about that. I think Sarah's going to talk in more detail about reasonable adjustments. So moving on then to contraventions of the Act. Starting then with discrimination. Discrimination is obviously going to be relevant to all protected characteristics, but there's a distinctive nature of disability discrimination, and that's reflected in the concepts of discrimination arising from a disability and in the reasonable adjustment provisions under the Act. So I'm going to talk about 4 types of discrimination. The first is on the slide, section 13, direct discrimination. So this type of discrimination is about different treatment of 2 individuals. The reason for that is the protected characteristic. So the elements that you'd need to make this out would be that there's different treatment compared to a comparator, that this treatment was less favourable, and that the reason for the treatment was the protected characteristic. So dealing first with different treatment. On the slide is a section there, 23. The comparison must be such that there's no material difference. So it's a materially similar individual. An slightly alternative approach is to focus on the reason for the treatment. So where the reason for the treatment is demonstrably the protected characteristic, it follows that without the protected characteristic, the treatment would be different. So you can look, the Code of Practice at paragraph 3.27 is quite helpful if you're stuck on that issue with a case. So the second part of what you need to make out less favourable treatment, there's no need to show actual loss. Some things such as the removal of choice would amount to less favourable treatment, but it must be more than merely unreasonable treatment. The Act provides at section 13.5 that racial segregation is unfavourable treatment. So you might say that you could generalise from that to other protected characteristics. And 3, the reason for the treatment must be the protected characteristic. So causation, the precise degree of correlation is unclear, but it must be because of, which means on the grounds of. So in terms of this first type of discrimination, then I'll just make 5 final points in conclusion. Firstly, there's no need to prove intention. Someone's motivation could be benign, they could act subconsciously, or they could feel that it was in the best interest of a person. And it only needs to be a cause. The Act wants to eliminate any discrimination. Secondly, it's wide enough, this section is wide enough to mean another person's protected characteristic, not necessarily one's own, although the associative discrimination provisions might be worth considering as an alternative there. Thirdly, the provision is not frustrated if the protected characteristic is shared, which is important to remember. And fourth, there's no justification for direct discrimination under the Act, unless it's going to come under one of the exceptions, such as the positive action provision at section 158. Unless the treatment is going to be brought under that, there's no justification for this type of discrimination. And fifthly, in conclusion, except in relation to disability, protection under direct discrimination is symmetrical. So the Act requires that people be treated in the same way. So more favourable treatment of one is going to be discriminatory to the other. For instance, both men and women are protected against sex discrimination. However, in recognition that disabled people must be treated more favourably if they are to have equal access, the Act provides, as section 13.3, the Act protects only disabled people against direct discrimination because of disability. So section 13.3 is worth looking at. Moving on then to the second type of discrimination. This is discrimination arising from disability under section 15. This addresses disability when the unfavourable treatment of a disabled person is where the reason is not the disability itself, but something arising in consequence of the disabled person's disability. I'm going to say 5 things about this. The section 15 test that we're looking at now does not require a comparison. Secondly, it's not necessary for there to be a direct causal link between the disability and the unfavourable treatment. It's the thing that arises that must be the reason. Thirdly, there's a justification of proportionality, potentially. Fourth, a person can show they did not know or could not reasonably have known, and they will not have discriminated for the purposes of section 15. And fifthly, however, where a person's agent knew, they will be taken to have known, usually. The code at paragraph 517 is helpful there. If failing to make a reasonable adjustment, it will be difficult to justify discrimination arising from disability. It's the code at 5.21. So the third type of discrimination section 19 is substantively different. It's concerned with equality of outcome. So here, an apparently neutral provision can have a disproportionately adverse effect. So the provision or criterion, for instance, that should be interpreted broadly. So PCP will be interpreted broadly, but the relevant case is rather old. It's from 2006. The Court of Appeal in a more recent case has said, generally speaking, all 3, so PCP, all of those will be ways of describing how similar cases should be treated. So I'll make 5 points about section 19 discrimination. So firstly, it's comparative disadvantage. It's only hypothetical, and there's no need to establish an actual situation. Secondly, there's no need to establish a causal link between the PC and disadvantage. There's no need to show why. And thirdly, proportionality justification is also available under this provision. The PCP must be proportionate to any legitimate aim that's identified, and it must be necessary. Generally, it'll not be reasonably necessary if another less discriminatory measure might have worked. That's a case of Chief Constable and Homer, although Lady Howe makes a very similar point in Astor Communities about proportionality defences to possession. Fourth, the closer it is to direct discrimination, the harder it will be to defend. And that's from the case of Elias. And fifthly, the motivation. It does not matter whether it was intentional for indirect discrimination, but the motive will matter for remedy. Section 1195 gives us that, and we know that the court will need to take into account intention and consider other remedies before they will award damages in such a case where the defendant can prove it wasn't intentional. The case of Nur gives some good examples of indirect discrimination. It's essentially an allocations case where the allocation scheme had a discriminatory effect. I won't talk about it in a great deal of detail, just to mention it, and it is on your slides. So the fourth, I said I was going to mention several types of discrimination. The fourth is reasonable adjustments. So I'll make 5 points about it. Firstly, the duty is under section 21. However, that is section 20, sorry, but that's not a cause of action in itself. It's a breach of the duty that gives you the cause of action. I think the slides will describe the relationship between section 20 and section 21. That's the first point to make. So you must read section 20 and section 21. The disadvantage must be substantial, which means more than minor or trivial. Once you establish that an adjustment is reasonable, refusing can't be justified. Fourth, there's an objective test of that reasonableness. And fifth, it depends on all the circumstances of the case, whether it's reasonable to make the adjustment. So section 20 is essentially made up of 3 limbs. The first is on this slide. The first requirement is a requirement where a provision, criterion, or practice of aid puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, to take such steps as it is reasonable to have to take to avoid the disadvantage. The second is concerned with physical features. And the third is provision of auxiliary aids. So section 21.2 provides, well, section 21.1 provides a failure to comply with the first, second, or third requirement is a failure to comply with the duty to make reasonable adjustments. And section 21.2 provides that A discriminates against a disabled person if A fails to comply with that duty in relation to that person. And the thing to note there is if you're under part 4, the second requirement generally won't apply, so physical features doesn't apply. So it's a slightly more limited duty under part 4 as compared to part 3. And then finally from me, I'll talk briefly about section 26 and section 27. So harassment is covered by section 26. A engages in unwanted conduct related to a relevant protected characteristic, and they therefore harass a person. This is obviously a broader definition of harassment than that which you will find in the PHA or the PEA. So it's worth pleading alongside, if your facts allow, it's worth pleading alongside both of those. And there's more detail on that slide about it. Victimization under section 27 is very specific, and the definition on the slide applies. I think, without wanting to go into Sarah's section, that's all from me.
Thanks, everyone. Thanks, everyone. We're going to hand over to Sarah, who's going to talk to us about practical tips for getting through Equality Act claims and getting the best damages awards, and also more specifically reasonable adjustments.
Oops, I'm going to try and build on the framework that Ria has set out to, as I say, go through some of the issues that come up most frequently, and to look in a bit more detail about reasonable adjustment claims, partly because I think that they're perhaps one of the more complicated aspects of the Equality Act, and also because I think it's something that we get wrong quite a lot, unfortunately. And so hopefully I can impress upon you the importance of sort of following through the framework, following through the mechanism that you need to follow through on a reasonable adjustments claim. So the first question, this is really fundamental for reasonable adjustments claims, is whether you're going under part 3 or part 4. And Ria's already talked about this a bit, so I don't want to labour it too much. But the important point here is it's not your right of election which one you go under. You don't get to sort of pick a menu of things under the Equality Act and choose which one you're going to follow. The way that the Act is structured is that you first ask whether it fits under part 4. And when considering whether or not this is a part 4 claim, you take into account section 32(3), which excludes some accommodation, quite limited accommodation, from falling under part 4. So that's going to be the really obvious things like hospitals and prisons, children's homes, I would suggest as well. But it may also cover, for example, interim accommodation that's provided pursuant to the homelessness duty. It doesn't mean you can't plead cases in the alternative, but you need to recognise that you can't choose to go into part 3, which would in a lot of circumstances be far more favourable. And I'll explain why it's much more favourable usually to go into part 3. So we ask whether it falls under part 4, sorry, and only if it does, are you permitted to go under part 3 instead. We've got 2 cases that show how this might work in practice. So we've got Ria and Zia's case from last week, I think, of FG, which basically found that when a local authority is exercising its landlord functions, that falls under part 4 instead of under part 3. And in that case, the court distinguished NER, which was looking at allocation schemes. So allocations of permanent accommodation, as opposed to a need for a decant or a need for a move, which arose out of the conditions in the property itself. So that's a case that is worth reading for understanding the distinction between the 2 parts and how they operate. And then Plummer and Royal Herbert Freehold Limited, which again Ria mentioned. I mean, that one's quite interesting because I have to say I'm slightly dubious about the legal reasoning of it, but it was favourable, so let's just celebrate it. This was a person who lived in a development that had a sort of on-site leisure facility, and as part of the long lease you had a right to use the on-site leisure facilities, but they were also available to members of the public on a membership basis, and there were relatively few members of the public that were members of the leisure centre, but nonetheless it wasn't restricted only to tenants in the development. And Mr. Plummer wanted a sort of a hoist system so that he could use the swimming pool. And in that case, and it's only a county court case, but it's just an interesting example of how you can potentially carve up a case like this. What was said was that essentially the leisure facilities fell under part 3 because they were a service provided for members of the public, whereas his property, his tenancy fell under part 4. I think the difficulty with that, as I say, not wishing to be too negative, is that part 4 expressly covers facilities that you can use as part of your rights under your tenancy. And there is that hierarchy that I mentioned. So it's slightly difficult to see how it doesn't fall under part 4, but there we go. That was what the court decided, and it's a great outcome for Mr. Plummer. So the reasonable adjustments duty, and as I say, Ria's already been through it to some extent, but I'm going to drill into it a little bit more. So the first requirement is the one that we're normally going to be looking at. That's provisions, criteria, or practices, or PCPs, as we refer to them in short. That's mostly what we will be looking at. Secondly, physical features. This only relates to part 3 cases, not to part 4 cases. The third requirement relates to auxiliary aids. Interesting question as to how auxiliary aids applies in a premises case, and what auxiliary aids might be, and where you might draw the line between physical features and auxiliary aids. So for example, if you need a hoist, if you need, probably not grab rails, because grab rails are going to be more sort of obviously something reasonable, but the provision of certain disability aids, if they go to your use and enjoyment of the property, as opposed to something that you need intrinsically for yourself, it's not going to cover the fact that you need a walking aid, for example, or a walking stick or something like that. But if it's something that you need to use the toilet, for example, then that may well be something that would fall under the third requirement. So to run through exactly what the duty is. So I'm going to use provision, criteria, practice because it's the most obvious one that we would normally use. I get a lot of defences to discrimination cases which say this wasn't a PCP. I mean, it's a terrible argument because almost everything is, as long as it's framed correctly. It doesn't need to be a firm practice or a formal practice. It doesn't need to be something which is in writing. It doesn't need to be something which is always done, but it does have to represent, there's a case which I haven't put there, which described it as some sort of continuum, or the sense that this is the way that things are done. So there has to be some sense that this is the way that things are done, even if it's not written down, even if it's not something that operates without exception. What you can't do though, and this is what happened in Bagley, the court said, what you can't do is list everything you don't like and label them as failures to make reasonable adjustments. And it is quite tempting to do that, but you do have to always go through this process of what's the PCP, what's the disadvantage. And usually when you identify the disadvantage, actually that may then lead you to recharacterize or reformulate what the PCP is, so that it all sort of lines up together. And there's a case in the Court of Appeal called Griffiths, where it wasn't until they got to the Court of Appeal that the Court of Appeal said, well, actually you're formulating the PCP all wrong. You need to formulate it like this. And once you formulate it like this, you can see you can see how it all hangs together. That was a case which was looking at absence from work policies. So, and the way that it had been formulated in the Employment Tribunal and then up to the EAT was to say that the PCP was the absence from work policy. And the employer said, well, actually the policy allows for disability related leave, and it has all sorts of elements of discretionary decision making and so on. So that policy doesn't discriminate against you. And the Court of Appeal, and this is the third court that it went to, the Court of Appeal said, no, the PCP is the requirement to attend work every day. That's the PCP. And you're at a disadvantage in relation to that PCP because you can't attend work every day. You can only attend it on a more limited, attend work on a more limited basis. And once it was understood in that way, you can see how then the claim hung together. The policy itself, the formal policy, was only the employer's attempt to sort of put a framework around that sort of decision making. Okay, so the next point is then substantial disadvantage. So there's an important distinction here between Part 3 and Part 4 cases. So when we're looking at Part 3, references to a disabled person are to disabled persons generally. That doesn't mean that every single disabled person has to be at a disadvantage. What it means is that sort of an ascertainable, identifiable group of people would be at that disadvantage. That might be, for example, so in Poorly, it was wheelchair users. And there's a great deal of flexibility as to exactly how you might frame that. And there hasn't been a case that says this is exactly what it means, but we know that it's to do with having some particular constellation of difficulties or impairments that give rise to the substantial disadvantage. So substantial disadvantage is not just a sort of a free-floating substantial disadvantage. In Part 4 cases, it's a substantial disadvantage in relation to the enjoyment of the premises. or the use of a benefit, facility, or entitlement that arises from the letting. This distinction actually comes up quite a lot, or at least it seems to come up quite a lot for me. Things like pets, and actually the Thomas Ashley and Drum Housing Association was just such a case, where the disadvantage in not being permitted to have a pet didn't relate to the enjoyment of the property. The tenant in that case needed a pet for his mental health more broadly. It didn't concern his ability to access, use, or enjoy the property. When we're looking at enjoyment of the property, we're not looking at enjoyment in a sort of having a great time kind of way. We're looking at enjoyment in the sort of legal property law sense of being able to access and use the property. And that's what Beadles and Guinness Northern Housing Counties tells us. So that connection is really important. Where you've got a case where the disadvantage doesn't go to the enjoyment of the premises, the way around that is to use indirect discrimination instead. It's not a perfect solution because there are other problems that relate to indirect discrimination, but it is a way of getting around that problem. Part 3, when you're looking at substantial disadvantage, most of the time we're going to be looking at conferment of benefit cases. So, and the benefit is going to be the allocation of housing, probably, or the allocation of suitable housing, or the provision of a homelessness service, or something of that nature. The distinction is public functions that are sort of by their nature adverse, being arrested, being detained, those sorts of things. Obviously, everybody has a bad time being arrested. And in those circumstances, it's about whether you've had an unreasonably adverse, to ignore it, you've experienced some particular detriment. But we're going to be looking at benefit cases, and so it's being at a substantial disadvantage in relation to the conferment of the benefit, i.e., are you less likely to get a house, for example? Are you less likely to get interim accommodation? Are you less likely to be accepted as homeless? It means substantial disadvantage. Substantial just means more than minor or trivial. It is not a particularly high hurdle to establish, and essentially, if it's bad for everybody, but it bites harder on the disabled, then the duty arises. At the bottom of that, where it says burden on C to prove, I mean, I almost hesitated to putting that because I just hate that decision. It's just such a so that's my case, and it went horribly wrong. And you know about how it went right in the end, because in the end it went to the Supreme Court, but it went to the Supreme Court on another point. It went to the Supreme Court on the issue of mandatory relief in housing cases. But at first instance, it was also a discrimination case, and we failed on that, and we shouldn't have failed on that, but we did, and we got refused permission. So unfortunately, that was a case in which the court said that we hadn't established that there was a substantial disadvantage. And essentially, the reason for that was that we relied on the other side's evidence, and the judge didn't like that. So we said their own evidence, the local authority's own evidence says we don't have any disability adapted accommodation. And they're going to have to wait a really long time because we don't have any disability adapted accommodation. And we said, well, obviously that's a substantial disadvantage, but the judge didn't like that. So I mentioned that as something horrendous to be aware of. And yeah, curse the judge. Anyway, so I think I might have had 2 slides on the same thing. Okay, and so the comparative exercise, you don't normally need to worry too much about the comparison in reasonable adjustment cases, because most of the time it's obvious. It's obvious what the disadvantage is, and it's obvious once you've established that your client has a disadvantage because they can't get up the steps or whatever it is, then the comparison is straightforward. But there will be those cases where it's not so obvious, and you do have to be conscious that this is still part of the requirement, particularly in Part 3 cases, because in Part 3 cases, you're looking at disabled persons generally. Thus, that is also the comparative exercise. So you end up with something which is much more like indirect discrimination, where you're comparing one group with another group. So when the duty arises, in a Part 4 case, you must make a request for adjustments. There is no need for it to be in any particular form. That said, obviously from a strategic point of view, the better you can evidence it, the better, the stronger position you are in. And so if at an early stage in proceedings, whether it's in the body of the defence or whether it's in correspondence, you say, I believe that disability is established, here's what the PCP is, here's what the disadvantage is, I say you need to make these adjustments, and I say that they would be reasonable, and I'm requesting you to do so. Obviously, if you can do that, that's great. I'm particularly fond of making those sorts of requests at the stage of adjourning or agreeing a suspended order or something of that nature, because then you've got a sort of watertight new circumstances that you can raise in the event that it goes wrong further down the line. Note that under Part 4, the claim can be brought by the tenant or by someone who is entitled to occupy. This is important because in disability cases, because it must be the disabled person who is the claimant. You can't bring it on behalf of some other family member. There isn't the same scope for associated or perceived discrimination as there is in other areas. The disabled person must be the claimant, and that might be a child of the family, for example. It might be somebody else that lives in the household but is not the tenant. Part 3 is an anticipatory duty, and I'm going to go through what that means. There is some uncertainty, controversy about exactly when and how the duty operates when it's an anticipatory duty. So I'll tell you how I understand it, and I think I'm right, is that the duty exists to the public at large. It exists in relation to disabled persons generally. And that means that the public body or the service provider must always be thinking ahead, thinking about what situations might arise and so on. But remember, you don't actually bring a claim under Section 20. You actually bring the claim under Section 21. That's what gives you the jurisdiction. And so, whereas you have the duty which exists and has arisen long in advance of your client having any interaction with the defendant in the case, it only crystallizes as a claim once there is a failure to comply with that duty in respect of that individual. That's when it crystallizes as discrimination. But the fact that it's an anticipatory duty, so as I say, it's not about the duty. There are some cases that refer to the duty arising once a public body or service provider is on notice. I don't think that's the right way of thinking about it at all. The duty exists, whether or not the public body is on notice will be relevant to the reasonableness of any adaptations or adjustments that need to be made. But it's not in itself something that's relevant to the legal duty arising. This is just what I've already said, really, that it's an anticipatory duty, which means that public bodies and service providers must be thinking ahead, planning, thinking about what kind of barriers people might have, and one or more kinds of disability. That's really important, because all the time what we see are very limited sorts of planning in respect of disabilities. So we'll come on to this more in a minute, but when was the last time you came across any sort of alternative being proposed to having to turn up in a homeless person's unit and wait there all day? Which, if you're a person who has autistic spectrum disorder, for example, it's just going to be completely unmanageable and cause enormous amounts of stress. So there's often no planning at all in respect of neurodiversity. There's very little planning in respect of mental health conditions at all. I mean, frankly, if a local authority can't even manage a sort of, a ramp to their front door, I don't know how they're going to think about the fact that they might need to plan ahead in terms of allocating temporary accommodation or anything of that nature. So there really needs to be some sitting down and thinking about how different sorts of disabilities can be accounted for. But given that this is a talk about damages claims, you can be confident that they've never done that. And it's that sort of lack of forward thinking which is what supports your claim that the adjustments that you are proposing would have been reasonable. They would have been reasonable because if they'd have sat down and thought about it, they would have realised that some of their homeless applicants, for example, are going to have autism. They would have thought about the fact that some of their applicants might have agoraphobia and not want to leave the house, and things of that nature. So yes, again, shouldn't wait until a disabled person wants to use the service before they give consideration to their duty to make reasonable adjustments. Failure to anticipate the need for an adjustment may create additional expense or render it too late to comply with the duty to make the adjustment. It may not of itself provide a defence to a claim of a failure to make a reasonable adjustment. And there's a case which I may have put the note further down, but it now seems like a good time to talk about it. There's a case called ZH and Metropolitan Police, which is actually, it's a good example of just failing to think ahead, really. And it's factually helpful because it was a very fast moving incident. So it was an incident at a swimming pool involving I think a teenager who had fallen in the water or something of that nature. And he was quite severely autistic. And the police turned up and just didn't deal with the situation very well. The situation escalated, that caused enormous stress. And the police said, well, this was all very fast moving. We're not medical experts. We don't know. We're not carers. We didn't have any information on autism. We didn't know what to do. We did the best we could in the fast moving situation that we were in. And the Court of Appeal said, autism is not so unusual that you shouldn't have been expected to have had information in advance, to have done some training, to have thought through what happens when you deal with a young person who has those sorts of difficulties. It's not so unusual. And frankly, if they were able to succeed in their claim in that case, in a situation which all took place in a matter of minutes, when we're writing letters to homeless persons units, for example, saying, can you please make sure that when my client is evicted that he's got somewhere to go to, because he needs to he has a strong need to plan ahead, to have some stability and so on. Well, I mean, they can sure as hell do that. They ought to have systems in place that allow for that. Yes, so that's the case. Sometimes called H, sometimes called ZH. So yes, a few more examples there from this. This is from the Code of Practice, basically talking about that need to plan ahead. So if you're planning an event, what sort of chairs do you have, or do you have some other ones that are available? This is a post office, but you can readily see how inability to queue for long periods of time also applies to homeless persons units. Oh, I like this one. This is to do with provision of information in Braille. But the real point is the fact that in this example, the software which the service provider is using doesn't allow them to flag a person's need for reasonable adjustments. So even though they've asked again and again for letters to be written in Braille, nonetheless, they keep getting sent in standard form. Well, I don't know how many of the big landlords have got a system for recording reasonable adjustments. I suspect not very many. And that if you ask for letters to be sent in large print, I mean, I had a case that was going on for a good few years where the client needed 18-point font, and they just kept sending it in 12-point again and again, even when proceedings had been issued. It was absolutely baffling, but it was just because they didn't have a system that actually allowed them to make a note of it, to say, no, correspondence to this person needs to go out in this way. And that point about having systems, I mean, it's a really important sort of pleading point, cross-examination point, but it's also something that can be raised earlier on in proceedings. So the reasonableness of the adjustments, as Ria's already said, this is an objective test. And so far, so obvious. This is, I suppose it's a good case for looking at the interaction between the PSCD and the anticipatory nature of the duty to make reasonable adjustments. So again, I mean, in this case, the Secretary of State was running I've forgotten what you call them, immigration place where you go to live. For some reason, the word has massively escaped me. I want to say camp. It's not a camp. But anyway, the Secretary of State was not monitoring the particular people who lived there who had disabilities, and thinking about whether or not they needed for things to be done slightly differently. Just didn't have a system in place for allowing that. And so again, always thinking when we're dealing with large organisations, what is the system that exists? Because we're looking at an anticipatory duty in Part 3 cases, it's about setting up the system so that it works immediately when you ask it to work, rather than dealing with every single case as if you're the first disabled person that's ever tried to make a homeless application. It shouldn't be that way. It should be about systemic change. And actually, we can be a part of making large organisations put in place those changes. A step does not have to be effective in order for it to be reasonable, as long as it gives the person a chance. So when we're looking at reasonableness, one of the things that we're looking at is whether or not a adjustment would be effective to eliminate the disadvantage. In employment cases, this is often concerned with people who are sort of so unwell that they can't do their job. And so the question is whether with adjustments, they would be able to do their job. But of course, a similar thing applies in relation to particularly tenancy possession cases, particularly where we're looking at breaches of behavioural requirements in relation to tenancies. So every tenancy has either an express or implied obligation to behave in a tenant-like way, and frankly, to behave themselves, not to cause nuisance. Most of the time, it's going to be in a written tenancy agreement, but it would be implied even if it's not there in writing. And we have a lot of clients who are unable to comply with that behavioural requirement because they have a delusional disorder, for example, or something of that nature which causes them to behave in a way that is in breach of their obligations. In those circumstances, it's going to be a pretty rare case where you say an adjustment is just to allow that situation to continue. There will be occasional cases like that. So I did a case of Cara Williams and Rosebery Housing Association, and we said in that case, actually, no, you just need to put up with her behaviour because it's causing a minor interference with the neighbours, and by contrast, her right to live in her property is pretty fundamental. But those cases are going to be really rare. Most of the time, you're trying to think about a solution that's going to give your client a chance, looking at that test, of being able to comply with their tenancy agreement, whether that's by the provision of some support, whether it's by moving to other accommodation, or whatever it is. And the duty is only at an end when there is either no disadvantage or where there are no further steps that could be taken. So I'm running out of time now, so sorry. Yeah, don't worry, there's some examples here, which you can have a look at later. All right, so I'm going to just briefly, more briefly than I had hoped, but that's because I have over-talked. I'm just going to go through some of the particular sort of areas in which these sorts of issues arise. So first, adaptations. I'm not going to say very much about this because you've got a seminar coming up on adaptations specifically. But I did want to just make clear that while you're never going to get adaptations under the reasonable adjustments duty, not directly. And that's because if you think back to part 4, the second requirement, which was physical features, doesn't apply in part 4 cases. So you're never going to be able to use that. But what you can get is permission to make the adjustments yourself, to make the adaptations yourself. And because that falls under a PCP, i.e. the refusal to grant you permission, rather than making the adjustment, making the adaptation yourself. And that was one of the things that was held in Smales. And Smales, it's only a county court case, but it was, you know, 2 very well-respected counsel on each side. It was very well argued, and argued at great length. So I don't see any reason why another court wouldn't follow exactly the same rationale. A lot of the reasoning in it was to do with a change in the language between the Disability Discrimination Act and the Equality Act. So, you know, nothing about that is obviously going to change. Something to note in passing was that in Smales, the Section 26 harassment claim also succeeded. And that was because essentially Miss Smales had been made to feel a bit of a pariah as a result of asking for these adaptations. And it included things like walk or moving past the directors and having them all stop talking when she walked past them. So it was things like that. So she succeeded on her harassment claim. Going to say a little bit about homelessness, although I've already touched on it. But Ria mentioned in relation to allocations that we would normally bring these cases as a judicial review. That was looking at allocations. The same would obviously often go for homelessness. And if you need to raise any issue in relation to part 7 or part 6, then obviously it needs to be a judicial review. But if the only issues that you want to raise are in relation to the Equality Act, There is absolutely no reason why you can't bring it in the county court, and there might be advantages in doing so. And that's because section 1192 provides that on a claim under the Equality Act, the court has the same powers as the High Court would have on a claim in judicial review. So you can get a quashing order, and you can get a mandatory order, and you can get injunctive relief. You can get all of those things on a county court claim. And in addition, you can get damages, which you can't get in the High Court. You can't get that on a judicial review claim. You can, if you're pursuing the case as a judicial review, you can get it then sent back to the county court for a determination as to damages. But there might be reasons why you might want to pursue it in the county court instead. So there are pros and cons. As I say, if you're not going to be able to raise any specific housing law questions in the county court. So that's an obvious disadvantage. On the other hand, you might think that the advantages of getting full disclosure as opposed to a partially complied with duty of candour, you might think that getting full disclosure and having the opportunity to make applications for specific disclosure, for example, making Part 18 requests for further information, all of those things, you might think that actually that's more of an advantage, having the opportunity to cross-examine witnesses, being able to properly challenge the other side's evidence in a way that on a judicial review, you just never can. So if you've got a factual dispute with the other side, you may well think that it's a lot better to run that in the county court so that you can challenge it instead of in the High Court, where of course, whatever the local authorities say is going to be accepted. That's going to be accepted as fact. So as I say, pros and cons. On the other hand, county court's going to take an awful lot longer, whereas the High Court probably bring it through to hearing fairly quickly. And especially if you need interim relief, that's going to be a lot easier in the High Court. So I just had put a sort of list of things that you might want to think about in terms of homelessness. And there's another list here. All the sorts of things that I'm sure you have come across, how the procedure is handled, when accommodation is sourced, how accommodation is sourced. Often you will have a sort of sense of how things are done because you deal with some particular local authority all the time, but maybe you don't have any evidence. So FOI requests can be quite helpful in pinning down what is the actual policy, what's the actual practice, rather than just sort of, you might have a sense that what happens is they turn up on the day and get allocated whatever is available on that day. So possible PCPs, one offer, automatically discharging the relief duty after 56 days. Remember, it's discretionary. Using preferred suppliers. If you ask whether they use preferred suppliers, they will say yes. They all do. There's none of them that go out on the open market and start looking for accommodation for your client. And of course, if you're not looking on the open market, your pool of properties is going to be extremely limited. So that might be an obvious adjustment. And also, once you can get the other side to accept that they should be looking on the open market as a reasonable adjustment, you then also open the door to you saying, and I found this lovely flat and I'd like you to give me that one, please. You're opening the door to a sort of much more proactive approach, which is hopefully going to pay dividends. I won't take you through that. That was just an example to try and demonstrate the point. But as I'm running out of time, I'm not going to. So yeah, just, suggestions of things that you might ask for. Although there's no request needed on Part 3 cases, nonetheless, obviously, the clearer you can be about what you want to happen, the better. I'm also not going to talk about that, I'm afraid, just because we're running out of time. So bringing the claim, the county court has exclusive jurisdiction for discrimination claims, except if it is a judicial review. You cannot decide that because the value of your claim is so high that it should go in the High Court. It's just the way it is. Just the way it is. But equally, it means that, as I say, if you bring a judicial review, you have to get it sent back to the county court for a determination as to damages. Deadline is 6 months, so it's quite short, but don't forget, you can issue protectively. Time limits run from, if it's conduct extending over a period, from the end of that period, but beware, when it is an omission, so a failure to make reasonable adjustments, time runs from the date on which the would-be defendant made a decision, so decided not to do something, or if they didn't make a decision, from the expiry of the date by which they might reasonably have been expected to make those adjustments. So really, really important, because it might mean that time has run out sooner than you think. Remedies, as I've already said, a county court has much wider powers on an Equality Act claim than it has in other cases. Judges are really unaware of this. I have had so many judges witheringly tell me that they can't possibly make a quashing order, and then you point out that actually they can. But it's significant. And of course, they can also make injunctions. So if you need an adjustment, you can apply for an injunction to get it. And of course, you can also apply for an interim injunction if the facts support that. Ria's already mentioned that where indirect discrimination is unintentional, the court must first consider whether to make another form of disposal. Unintentional, however, in this context doesn't mean sort of motivation or motive. What it means is knowledge of consequences. So if you take a step knowing that it's going to cause a disadvantage to some particular section of the population or people with some particular disability, or I would say reckless as to whether or not it would have that disadvantage, then that is intentional. That's intentional discrimination. You don't have to intend to cause them a bad time, but that is still intentional discrimination. There is also obviously an interaction between some of these issues and the PSED. So remember that one of the things, and we often overlook this, but one of the three limbs that you're looking at under the PSED is having due regard to the need to prevent discrimination. So if you are designing some processes, if you're designing a policy, if you're designing a software system or a queuing system, or a scheme for allocating temporary accommodation, or whatever it is, the PSED applies at that stage. And one of the things that should be happening is thinking about how you're going to prevent discrimination from happening when your policy is used. And all of that informs reasonableness. So very difficult to say that a decision would, that it wouldn't be reasonable to make an adjustment if it's something that you ought to have thought about when you were carrying out your equality impact assessment. Damages, you all know about the Vento bans. The date, by the way, so you'll know that these get updated every year, but the date that you're looking at is the date that the claim was issued. So it might mean that you're having to rely on the previous year's set of numbers. Awards for injury to feelings are evidence-based. So it's not, they are not at all automatic. However, That doesn't mean, and Maria and I were talking earlier about clients who might be non-verbal, for example, doesn't mean that the evidence needs to be directly from that individual, but you do need to have evidence. So if you've got a non-verbal client, it might be that they express their distress through dysregulated behaviour, for example, agitated behaviour. And that might be something that you need to get evidence of. It might be that stress causes repetitive behaviours as well. So it's still something that you need to have evidence of. Aggravated damages are frequently awarded in discrimination cases. You might think that they would be sort of too much overlapping with injury to feelings, and there's no hard and fast rules about how you deal with that. But it is the case that aggravated damages will often be awarded, and they were awarded in Vento. And just in terms of how you get money, how you get as much money as possible, I think there was a period of time in which county courts were just sort of giving kind of token pluck from thin air sums of money. We may have been a bit guilty in going along with that, but that shouldn't be what happens. There are lots of quantum reports in the employment field. We're not very good at recording them in housing, and I think really somebody, if there's someone from LAG here, should start doing quantum reports in discrimination cases in housing. But at the moment, the best we can do is to look at employment cases and think about how they relate to our circumstances. So, for example, if you've got a case that involves physical discomfort, you might think about someone who has a sort of poorly fitted workstation that is causing them physical discomfort. If you're looking at a failure to make reasonable adjustments over a long period of time, then you might be looking at the period of time. Once you've got some comparable cases, you're then uprating those for Simmons and Castle, because that applies in discrimination, just like it applies in other sort of general damages type cases. And you're uprating them for inflation to account for the period of time. And of course, inflation rates are very high. That will give you a figure which is much higher than you think. And that's when you need to start. I mean, if we're talking about somebody who is nearly evicted, who has proceedings hanging over them for months and months, or someone who's in desperately unsuitable accommodation, or somebody, I mean, clients sat there in their wheelchair until late at night in the park, you know, awful situations. These are cases which warrant high levels of damages. And so you should be thinking about certainly the top half of the middle band, and in some cases, well into the upper band. I've talked way longer than I was supposed to, I'm sorry. But that's the end.
Thanks, that was extremely thorough, but has probably given rise to a couple questions. I reckon we can probably do about 5 minutes of questions.
I'm also around at lunch, so if anyone just wants to ask me a question afterwards, we can do that too.
I've got loads, but I'll do them at lunch. Anybody got any questions? Rebecca, so middle.
Hi, this is a question mainly for Sarah. You mentioned using the Equality Act as an alternative to JR in suitability cases. Of course, if at the section 1932 stage, it would normally be a suitability review, and those can be extremely frustrating and long drawn out. Quite often they aren't even completed within 8 weeks. So do you think the court would allow us to be, as an alternative, issuing Equality Act claims before a review, or would we be told off and sent back to do the review first?
I don't think you could, because at that point you don't have a decision about suitability, and I think you need to generate a decision about suitability, and you're not going to get that through an Equality Act claim. I think once you're in the situation of you've got either a finding or a decision that accommodation is unsuitable, I think it's one area where I think that probably you are going to have to judicially review it, because you really, what you're complaining about in that situation is a failure to comply with statutory duty. It's not really, the main body of your complaint is not really the Equality Act. But what you might do is you might subsequently bring a claim under the Equality Act in relation to the way that it was handled. So delays, I mean, in particular, when people need accommodation at short notice, and the systems aren't in place to allow that to happen, and it causes enormous harm. But in that situation, your complaint is really to do with their processes rather than sort of suitability per se and the housing law decision.
I think we've got a question over here.
Yeah, I was just wondering whether the unreported county court decisions that you mentioned could be included in the online pack, just because it's otherwise impossible to get them if they're not on Bailey
Those
or elsewhere.
Plumber and Smales are both available online. If you Google them, you will find both of those. I don't think I referred to any case that isn't available by a quick Google. But what I will do is I'll put together some links, and then they can be sent around to everyone.
Rosalie?
Hi, thank you. Just thinking about issuing in the county court and track allocation, because if you're on the fast track, you're going to be subject to fixed recoverable costs because it doesn't fall within the definition of a housing case unless it's involving possession. Whereas if you issue in the High Court, you don't have to worry about that at all until you get it transferred to the county court for the damages claim to run, at which time, if it goes on the fast track, again, you might be subject to fixed recoverable costs from then on.
Yeah, so I think most of these cases probably would be allocated to the intermediate track at some level, wouldn't they? They might still be multi-track because these cases are often quite complicated. But yeah, a lot of them are going to be on the intermediate track now.
Have you ever known them to be allocated to the small claims track on the basis that they're going to be on the lower bit of the Vento scale?
No case that I have been involved in has dared to try it. No, but I am aware that it happens. I mean, mainly I'm aware because I sit as a DDJ as well, and I know that other judges are allocating cases to the small claims track, but those are cases really where someone isn't represented and they've put in a sort of fairly flimsily formulated claim, and perhaps haven't really put a proper statement of value on it. So yes, I'm aware that it happens, but it doesn't happen in my cases. Part of the reason for that is that when you bring a freestanding disability discrimination case, you're going to be subject to the cost-benefit ratio on legal aid. So it means that legally aided cases that I'm doing as freestanding claims, they're all going to be significant value, because otherwise you're not going to get legal aid for it. Oh, sorry, there was something else I wanted to say. Fixed recoverable costs. I do have all sorts of ideas of trying to get around this, though. and don't forget that there is the sort of vulnerability exception, and I can't imagine a disability discrimination case where you're not going to fall under that loophole.
All right, any more questions, or are we through to lunch? One more in the corner. Sorry, hi.
I'm very sorry because you said just before lunch, I feel I should draw.
No, that puts undue pressure on you. Take it slow.
So I just wanted to ask about PCP, the PCP and burden of proof in terms of whether a case is kind of JR ready or not. And so I've got a situation where I've got a single mum and 2 kids, in theory would qualify for a 3-bed house. The local authority, basically every time they put a property up, they always say minimum 4 people in the household. So I think indirect discrimination, you know, if the lady had a she's a single parent mum. If she had a partner, wouldn't be a problem. Could also impact on disabled people as well. So I've gone down this rabbit hole with the local authority where I keep saying this is indirect discrimination because you're always setting a minimum of 4, and they're writing back to me and saying, no, we're not, there's no problem. So there's a dispute of fact about whether there's a PCP. In terms of whether a case is JR ready, I'm trying to go down this freedom of information route and not getting answers. Can I just go ahead and PAP for JR, and am I actually going to get proper disclosure from them if I do that?
You're not going to get proper disclosure,
or is there a better route I should be using?
I mean, if you're confident that that is the PCP, I don't see why you shouldn't start the process of PAPing. You might as well get it started. But I mean, I can't remember what the turnaround time on FOI request is, but it's not that long. Is it 4 weeks? You probably can make your FOI request before and get the response back before you issue, and you might be in a position then to sort of review whether or not you're going to be able to prove that that is a PCP. At the end of the day, you do have to prove it. You have to prove that that is the practice. I've come across this situation a few times where the sort of housing officer or whoever it is dealing with it initially says that quite a lot, and then as soon as it gets handed over to lawyers, the lawyers say, yeah, obviously that is our practice. So yeah, you may find that once you've gone into pre-action protocol correspondence that you get a more sensible response anyway.
All right. Any more questions?
Over lunch now.
Lunch. Yay. Thanks, everybody.
Hi, everyone. Welcome back after lunch. I am here with Monica Creel. We're doing a session moving away from sort of the more technical legal content, but a session that's really important about promoting the rights of our disabled clients. Monica is a solicitor at TV Edwards, who I have the great privilege of working with. She does community care, public law, and court of protection work. In a former life, prior to being a solicitor, Monica also worked in the disability policy and advice sector. And that included working with the Disability Rights Commission and then in turn the Equality and Human Rights Commission. The codes of practice that we use from the EHRC that are really helpful and that I know that Sarah referred to in her presentation were co-written by Monica. And some of those case examples you saw today were produced following significant consultation with disabled people. And I know Monica played a key role in that. So I can't think of anyone better to come and speak to us today about how we promote the rights of our disabled clients. I'm going to let Monica do a lot of the heavy lifting because she's got significant expertise. So she's going to start off by giving us a quick trot through some really important context that should really highlight the gap between how things are at the moment and how things are meant to be before we start talking about what that means for our clients. Occasionally I might pipe up and add sort of 1 or 2 sentences, but otherwise I'm going to hand over to Monica, and we're hoping for some time for questions, answers, experience sharing at the end of the session. So I'm going to hand over. Thanks, Monica.
Hi, everybody. Can you hear me okay? Good, good. Yeah, first slide. Just to tell you what I'm going to be talking about. Next slide, Alice.
I'm trying.
Okay.
So I've got one job.
Yeah.
Do we have somebody?
Oh, yeah, it would be good if it was up on there.
Can somebody grab Ray or similar? It was working a second ago. I think sorry, I can always head over. Oh, okay. Marie, champion.
Marie, you might be able to see what's on mine. Because I'm doing mine separately. It's not controlling that. So if you need to keep in step with me. So the first I just wanted to sort of explain what I'm going to talk about and why I'm going to talk about it. So you may be thinking that it's going to go launch straight in with some practical tips, but I wanted to give you a little bit of background history, because I think the history and context is really important, because as Alice said, you know, there is a significant gap between what we see in our day-to-day practice, what we see with our clients, and how the world is meant to look for disabled people at the moment, given that we've had decades of disability rights activism. Things should be better by now, but they're not. So that's why I wanted to give you a bit of history. So I'm going to try and keep the history to about 10 minutes, if you'll indulge me with a bit of history, if that's okay. So the context of all this, in the context of what I'm going to be talking about, is really the social model of disability, which people are probably familiar with, yes, which is really a different way of looking at disability. We're very used to, in our practice, sort of starting, you know, with people when we talk to people, what's your medical condition? Let's see your medical evidence. You know, it's all very, very medical based. But the social model of disability was developed really by disabled people to say, well, what are the barriers we're facing in society? You know, are the barriers our medical conditions? No, the barriers are a society which doesn't meet our needs, a society where reasonable adjustments aren't made, or a society which was never designed for us in the first place, whether that's the physical barriers or the attitudinal barriers that people face. So this is what Disability Rights UK say on their website, and they're the sponsors of one, a co-sponsor of this conference, I think. So they say, if the social model of disability was developed by disabled people and describes people as being disabled by barriers in society, not by our impairment or difference, if modern life was set up in a different way that was accessible for disabled people, then we would not be excluded or restricted. So that's the starting point. The social model of disability helps us recognize barriers that make life harder for disabled people. These barriers are identified as being the physical environment, people's attitudes, the way people communicate, how institutions and organizations are run, and how society discriminates against those of us who are perceived as different. Removing these barriers creates equality and offers disabled people more independence, choice, and control. And this is just another great quote, which just has some very simple truths in it. Do you want me to read it out, or I mean, I can read it out. The social model frames disability as something that is socially constructed. Disability is created by physical, organizational, and attitudinal barriers, and these can be changed and eliminated. This gives us a dynamic and positive model that tells us what the problem is and how to fix it. It takes us away from the position of blaming the individual for their shortcoming. It states that impairment is, and always will be, present in every known society, and therefore the only logical position to take is to plan and organize society in a way that includes rather than excludes disabled people. And I just think that last sentence is so powerful, because yes, you know, society shouldn't be like this. You know, the housing stock shouldn't be like this. You know, the services people get shouldn't be like this. You know, we shouldn't be starting from here. And I think that's the point. So just to talk you through really the last 30 years, more or less, last 40 years of disabled people's rights. I think that Clive mentioned this also in his presentation this morning. So, you know, other discrimination legislation came in the 1970s, but there was still nothing on to protect people from disability discrimination, whether that was in employment or access to services. So, you know, employers could just sack people at will, and there was no legal comeback to that at all. And then disabled people organized into organizations. There was one that was famous called the Direct Action Network, and there's some great YouTube clips of some of the demonstrations they did, chaining themselves to buses and things like that. They did some fantastic actions against, don't know if anybody remembers the telethons with Chris Tarrant back in the 90s, raising money for disabled charities. And it was this whole idea that disabled people really didn't like this whole charity model, seen as charity cases. And they did these demonstrations that were known as the piss on pity demonstrations, because they didn't want to be pitied, basically. Then there was loads of intent. So it wasn't just kind of direct action. It was that idea, that theory of change where you use direct action, but you also use political lobbying to make changes. And there was a lot of lobbying around trying to bring in disability discrimination legislation. And I was at some of those lobbies. I was working for a small disability organisation, took a load of our members. We went on a minibus and we lobbied the House of Parliament, and it was a great day out and it was very empowering. And the DDA came in 1995. It was enacted, but there were loads and loads of exemptions. It was just a very minimal bit of legislation at the time. It was groundbreaking, but it obviously didn't go far enough. Small employers were exempt because it was thought that, well, small employers can't possibly be expected not to discriminate because it would be too costly for them. So there was literally no protection at all for people who were working for small employers. The Disability Rights Commission was set up in 2000 because that came in after the DDA, because initially there was no enforcement body for the DDA. Under the Disability Rights Commission, through further lobbying, the DDA was extended in 2000 and 2005. There was actually a public sector duty which came in under the DDA, which predated the public sector equality duty under the Equality Act. There was loads of involvement of disabled people, and that was the really amazing thing about the Disability Rights Commission. I worked there for the whole duration of it, actually. The amazing thing, there was loads of involvement of disabled people in that organisation. So it was a statutory body, but we had a lot of leeway to do what we want, actually. And it was you know, a very progressive organisation. We managed to write some very, very positive code of practice that included really the views and the intentions of disabled people in those codes of practice. It was their voices that were speaking out in those codes of practice. And the DRC also supported some key legal cases that extended the definition, for example, of reasonable adjustments. Sorry, did I say the DRC? Yeah, the DRC. The UN Convention on the Rights of Disabled People came in and was ratified in 2009. And it's an unincorporated treaty, which means that you can't kind of cut and paste bits of the you know, of the UN Convention into your pleadings, because it's kind of the way that it works is kind of through other legislation, and that was tested in a case that that Jamie Burton took, actually, wasn't it, Davey? But an important thing that I just wanted to point out is that Article 4, it talks about really what states should be trying to achieve, states who signed up for the UN Convention on the Rights of Disabled People, what they should be trying to achieve. That there's a general obligation to abolish the legal barriers and promote disabled people's rights, to undertake to ensure and promote the full realisation of all human rights and fundamental freedoms for all persons with disabilities, without discrimination of any kind on the basis of disability. And the important thing to note is that with economic, social and cultural rights, there's this concept of progressive realisation. And the idea in a nutshell is that as member states who signed up to this convention, as their economies progress and as their societies progress, that they'll have kind of, you know, and as infrastructure is renewed, as economies grow, that people's access to resources, disabled people's access will get better, you know. So that kind of applies, you know, transport, you know, or housing or whatever. So that's something I want to come back to later, because that was the idea, that things would get better over time, and state parties who signed up to this convention would be sort of given a bit of leeway in that they didn't have to meet this absolute standard straight away, but they would be working towards these better standards. So the economic, social and cultural rights in a way were sort of aspirational, but they weren't so aspirational that they're, you know, centuries into the future. They were meant to be sort of realised fairly soon, I would say. There's some very important articles in the UN CRPD. There's Article 9, which is the right to live independently, and that includes kind of choosing where you want to live, not having to live in institutions. Am I getting towards the end of the 10 minutes? And Article 28, which is adequate standard of living and social protection. And I've just highlighted this bit. It recognises the rights of persons with disabilities to an adequate standard of living for themselves and their families, including adequate food, clothing and housing, and to the continuous improvement of living conditions. So, I mean, it's quite interesting looking at this, which was ratified in 2009, and thinking that, are we on the way, you know? Is there really progressive realization going on. So it's quite interesting kind of looking, well, I find it interesting, it might be a bit geeky, but looking back over the history of it and seeing where we are now. And then bombshell, there was a change of direction and we had austerity policies. The Disability Rights Commission dissolved into the Equality and Human Rights Commission in 2007, which was done, I mean, it wasn't really done as the reason it was done was because of the EU directives on discrimination, which brought in like what they called the other strands of discrimination. So it was sexual orientation and age discrimination and religious discrimination, which hadn't been, there hadn't been discrimination law on that before. And if those were going to be brought in, then would you need 3 extra commissions to enforce that law? So it was really done, you know, there were some positive things about it. And one of the arguments, well, you know, people aren't in little silos, you know, there's a lot of intersectionality, which wasn't called that then, but obviously people aren't in silos, and it would be good to have everything, have one commission that covered everything, including human rights. But the result of that is that because it was covering a lot more issues, it became a much more of a political football. And if anybody's tried to work with the Equality and Human Rights Commission recently, you'll realise how difficult it is to get something funded. You know, you say, well, this would be a great idea, wouldn't it? And the people you talk to there are very, very positive about it and say, oh, well, yeah, we can look into funding your case. And then nothing happens. It goes to a committee and it's invariably turned down. So that's my gripe at the Equality and Human Rights Commission, to be honest. I don't work for them anymore, so I can say it. There was the financial crash of 2007, 2008. We then had austerity policies of the coalition and Tory governments, although actually, to be fair to them, some of the welfare reform that Labour had tried to bring in before then started to have an impact on disabled people, a negative impact. We know the situation with local authorities now, so all of those cuts over the years have started to really, really bite on local authorities, and they're issuing Section 114 notices, they're going bankrupt, they're telling us on a daily basis when we write to them that they haven't got money for this and that and the other, and we're seeing services shut, we're seeing the effects of budget cuts, and you know, a prediction that 1 in 5 councils in England expect to issue a Section 114 notice over the next year. And a Section 114 notice means that they will only they'll cut their budget down to the bare bones and only do what they statutorily have to do. The result of this that we see on a daily basis, disability and poverty, you know, disability causes poverty, but poverty and inequality also cause impairment and disability. There's some statistics here, you can, you know, I don't think I need to read them out, but we know the situation is really, really dire for our disabled clients. People have tried to fight back. So the disabled people's organisations petitioned the UN CRPD committee in 2015. The UN committee found that there were grave and systematic violations of disabled people's rights. And they'd happened because of the welfare reforms, the changes to social care, the ending of the Independent Living Fund, and they found breaches of Articles 19, 27 and 28. And the UK government responded in their typical way, which was saying, well, we're fully committed to this. But this was a quote from Svetlana Kotova, who many of us have worked with, who works for Inclusion London, who said, the UK government says it is fully committed to the UN CRPD, but it could not tell the UN any steps it had taken towards the UN's recommendations given in 2017 when the UK was found to have committed grave and systematic violations of our rights. This is because there has been no progress since the government rejected those findings and all recommendations. We continue to be detained and kept in institutions with no progress towards our right to independent living, and the government is doing nothing to lift us out of poverty caused by its punitive benefits sanction regime. We hope the UN's further report will outline these failures and call for the government to make the drastic and urgent changes we need to enjoy our human rights like everyone else. So people are still fighting, people aren't accepting it, people are doing incredible things, including Disability Rights UK, who sponsored this conference. That's my plug for them. Right.
So we're going to pivot. Thank you, Monica. That's really important context. We're actually donating all of the funds that were paid today for you to attend will be going to Disability Rights UK. So we're going to pivot now to how that affects us in our practice day to day. And I agree wholeheartedly with Monica that the kind of gap between the aspiration and what we should be expecting for our clients and the reality on the ground is something that I'm sure we're all acutely aware of. So what does it mean for us in terms of what our clients are experiencing, and in turn, what can we do to empower them and hopefully push some change through our work with them. So I know that you've got a bunch of examples. I'm going to pitch in more in this section,
Okay.
but if you want to take it away, Monica.
Okay, just let me know, Alice, when you want to pitch
I'll
in.
just start talking.
So, I mean, we all know about gatekeeping. I think the term I think I first heard it used in a kind of a legal setting was in homelessness applications, but we see it everywhere. So we see it actually with the legal aid agency as well. So it's things like cuts to frontline staff so that you can't access the services, so you're holding on forever on the phone, or you're having to go through an IT system that's inaccessible. Staff without the specialist skills to understand the needs of disabled people. Tighter enforcement of rules, which we see a lot, you know, when there's eligibility rules like with the Care Act. Waiting lists for services, waiting lists for assessments or services. So you know, people can't even get onto the first rung of getting the service because they can't get the assessment in the first place. And sometimes just simply not doing anything at all. And I think this is something I've seen a lot with disabled facilities grants, actually. Yeah. People putting them in, and then when you get hold of the you know, when you get hold of the file, of the housing file, you just see that there was an application that was made and literally nobody's done anything about it. No decision's been made.
Even though there's a statutory time limit, which we'll be learning about later, for making a decision on that. On the Care Act eligibility, just very briefly, with things to look out for. Dan mentioned some of that this morning when he went through the example in relation to a client who has hoarding disorder. Often a narrow focus on physical impairments without a more holistic approach. So thinking about mental health impact. Also a binary kind of, can a person do X or not, rather than you meet the eligibility criteria if you can do something independently, but you can't do that without anxiety and pain, or if it takes you longer than would reasonably, or sort of normal, it's not the right word, but you know, the language of the legislation isn't very good around that, but it takes you longer than would be expected. So often you see assessments and it says, well, they can do X, but they've not asked the question about what toll that actually takes. So those are things to look out for in terms of poor quality Care Act assessments.
Or even just saying, well, we've done a, what do they call it? Just a quick assessment, a kind of a first frontline assessment, just to see if somebody needs a full assessment. And then they're just kind of kicked off at the first stage. They don't get through the first hurdle of having the proper assessment because they're just rejected at the first stage. Bureaucratic systems is another kind of barrier that people face in all sorts of dealings with public and private authorities. So that's more processes to follow before you finally get a service, a process of referrals that lead to other referrals. And we often have that, you have that a lot in the mental health sphere, that people are sort of kicked around from one thing to another. And then you can often have quite a long waiting list, even to get your first assessment in the with a mental health professional. And then you get that first, you know, people get quite excited and they're counting down the months to get this first appointment. They have the first appointment and then they're told, actually, we need to direct you to another service. And people then sometimes end up back at the beginning after this process that can take, you know, 1 or 2 years. Funding panels is another thing to look out for, even if it's quite a small decision. There shouldn't be funding panels for everything, but it has become quite normal in the social care field to have a funding panel for tiny spending decisions. and that shouldn't happen. Inaccessible IT systems are another huge problem for people, and we know that our clients are told to do this in a certain way and they can't manage to do that. And the result is that disabled people and their carers using all their energy to fight just to get to the first hurdle, really, and they feel very frustrated and exhausted. And then when they do get to speak to somebody, they're very angry because they've got all that pent-up frustration, and they're often labelled as difficult. And also they often just go into a kind of a mode of just being angry and difficult, and that can actually sometimes, we can experience that as well as solicitors. You know, the people are expecting that our clients, they've been let down so much and they felt frustrated for so long that they come to us and they're expecting us to let them down at all. So if we hint at anything that we can't do for them, if we hint at anything negative, they go into full-on frustration mode with us because they think that we're part of a system that's just designed to let them down.
Just one point on panels. No, not at all. Supported accommodation placements often go via panels, and I'm sure you've seen that. And I know that there's a solicitor in the room that we were working on a case with this where there can be a lot of opacity, and it varies from area to area in relation to how the kind of limited available supported or semi-independent kind of accommodation placements are allocated. So you want to be asking as many questions as possible in pre-action correspondence, and potentially thinking about FOI requests if you're not getting transparency around that, so that you're able to check how that sits alongside the statutory obligations, say under the Care Act, for decision making, because I think some of those are lawful. I have question marks sometimes about how they kind of hang together, because they often cede a lot of power to the people who are actually running the supported accommodation placements themselves to make decisions. But I've seen clients as well who've been assessed as needing supported accommodation, and then somebody outside of the local authority said, oh no, they don't, and suddenly that's been the decision. And I think that's something that's worth thinking and looking into, and asking a lot of questions, and different areas vary enormously. So really interested in any experience people have on that as well.
I mean, another barrier that I see a lot is, and cases that I've worked on with Alice as well, seeing discriminatory restrictions to services, and this in a way relates to Sarah's presentation earlier, that we need to look out for these things, because quite often, I mean, it can be in the context of other cases as well, of court of protection cases and things like that, that you'll just see something say, well, no, that person isn't entitled to that, and we kind of need to question why. So the types of, these are just some examples that I've seen, where, for example, wheelchair and seating services are not being offered to disabled people in care homes. Why? You know, somebody maybe if somebody just needs a very standard wheelchair to just go on a trip to the shops once in a while, or to go out to the care home once in a while, they might not, they may be able to use a standard wheelchair that's available in the care home. But if somebody needs a specialist wheelchair to be able to avoid pressure sores and to be able to have some independence, they shouldn't be denied that just because they're living in a care home. And that's a discriminatory policy. And if you challenge it, they will back down. So these things need to be challenged. Another one that we see a lot of is disabled migrants being denied services under the Care Act, and because they're also NRPF, they're channeled through the NRPF team, the No Recourse to Public Funds team at social services, but their actual needs relating to their disability are not being looked at, because they're just being channeled through one, and that through to the NRPF team, which is obviously unlawful, because that's completely disregarding any needs that they've got, any Care Act needs that they've got. Another one that I've dealt with a lot with Shushin is the issue of children's services refusing to recognise children with autism or mental health issues as disabled, and not giving them services under the disabled children's team unless they also have a learning disability, because for some reason they don't see autism as being a disability. and charging for services that should be free. So these are all sort of policies which are just worth looking out for and not just accepting. You know, even if it's kind of a side issue in your case, it's worth just maybe just writing an odd letter, just challenge, or a letter before action, or just asking them why. Where's the policy?
Brief note on NRPF. Just a reminder, and there have been a couple of cases that have affirmed that very clearly recently, that if you've got someone who doesn't have recourse to public funds but has accommodation related needs for care and support, they should be being accommodated under the Care Act and shouldn't be being pushed off into dispersal accommodation. And local authorities will often say, go to the Home Office, get accommodation, and then we'll look at your care needs in that accommodation. Obviously, dispersal accommodation is often quite grim and you have limited control over location. So it's always worth thinking about whether you can push the Care Act angle, and the Care Act does take priority over dispersal accommodation. So in terms of people being channeled in the wrong direction, that's classic in the accommodation context.
Yeah. And another thing that we see all the time is disabled people not being believed. So just relating this back to my first slide about the social model of disability, this is about as far away from the social model as you could possibly get, demanding medical evidence for absolutely everything. I mean, why on earth somebody would say that they needed to have support to go to the toilet at night when they didn't actually need it? I don't know why somebody would have to prove that, but every little thing disabled people have to prove, and this kind of constant demand for medical evidence is very, very wearing for people, having their whole lives dissected into every medical condition that they've got. And it also makes it difficult for us because we're having to put those people in that kind of pigeonhole, asking them for medical evidence or setting their lives out in such a medicalized way all the time. And part of that process of not believing disabled people or their carers is the sort of the process of which I'm seeing more and more is intrusive and inhumane assessments of people, particularly this idea of a reablement assessment where people are observed by social workers or occupational therapists going to the toilet or having a wash to see how it's actually done. And I've got a case at the moment where a 90-year-old woman with dementia had a reablement assessment involving 6 people, an OT, 2 care workers, a care agency manager, an interpreter, and a social worker, who watched her being stripped from the waist up, completely naked from the waist up, and washed. And the purpose of this reablement assessment was to see if the care could be delivered in a quicker or cheaper way. So that's something which I feel has definitely come in over the last, I mean, I've started to see this more and more in the last maybe 5 or 6 years, these reablement assessments. And if you actually look at the Care and Support Statutory Guidance and what reablement is meant to be, it's not meant to be that. It's just not meant to be that. But now there's this idea, this idea of reablement has crept in, and that's how it's being used, to deny services rather than to actually enable people to do things. Sorry, I'm not giving you time to come in.
I'm only coming in if I have value to add, and you're doing a wonderful job.
Okay. So again, going back to the social model, and this actually is my pet peeve, to be honest, is that the language of the social model, we see it constantly subverted. When we read assessments of people, we see social services jargon. We just see it all the time. So this idea of resilience, I saw the word resilience creep in, I think, maybe about 8 or 9 years ago, something like that. The word resilience started creeping into loads of Care Act assessments or social services assessments. And the concept of resilience, and I think I'm going to talk about it later actually, it comes from this idea of vulnerability theory, which is actually meant to be the word resilience. It was meant to the idea, well, I think I might say it now. Vulnerability theory is really a critique of the concept of vulnerability. It's saying that we're all vulnerable as human beings. all human beings, as we're all vulnerable. If we don't have a society around us to support us, you know, if we were left on our own in the wilderness, we'd all be really, really vulnerable. And it's society around us that actually protects us. And the more sort of economic power or social power you've got, the more resilient you are. And that's where the idea of resilience comes from. But now it's actually being used by services to say, well, let's take away this service because we think you could be more resilient, or we want to make you more resilient. So that's one example. Another one is equality legislation. Is this idea that, well, you've got equal rights to access these publicly available services, so you don't need any special social care services. You don't need anything extra, because you've got your equality legislation now, so the world's perfect for you. So that's another way that things are removed, and we can see that also in the world of benefits as well, with the and that started to come in actually under the end of the Labour government, when you had the work capability assessment. I think that's when it came in, was this idea that that you've got equality in the workplace now, just because the Disability Discrimination Act had come in at that point. You've got equality in the workplace, so it should be these reasonable adjustments in the workplace that are helping you to get work, and you don't need to have extra benefits now. That would just be patronising, wouldn't it, to give you extra money? And then it's the same with this idea of strengths-based assessment. This was something that Alice mentioned to me.
Yeah, this drives me wild, because I'm seeing strengths-based a lot in social care assessments. And I trained as a social worker, well, sort of did an academic portion of the training, and this is what I was taught when we were being trained to be a social worker, and the way it's being used is completely and utterly different. So again, it's meant to be focused on recognizing that when you approach somebody, whether that be an individual or a community, you don't just look for deficit, but you look at strengths and resources that they can bring and use and build on. And often actually we would talk about that in the context of community rather than individuals, and thinking about what can this community do to help themselves address the things that are, you know, challenging. But now again, it's being used in a way to say, oh, well, we don't want to patronize you and all of that. So it makes me pull my hair out, given what when you see what it ought to have been and then how it's now being used.
And obviously we experience this every day, is the barriers in accessing justice. Since LASPO came in 2013, and which limited the scope of legal aid, and the JR regulations, which said, you know, you don't get payment without permission apart from interim relief. So there's a lot less challenges to public authorities now, because it's much harder to take a JR, because we're all told, well, you know, you might not get paid at all, and your department might go bust if you work in private practice, if you issue proceedings. So it's much fewer challenges going on in terms of JR. It's harder for people to find a legal aid solicitor. It's harder for legal aid solicitors to get paid for the work that they do, or to get experts, because the expert rates are so low. We've got problems with the courts, and Alice is going to say a bit more about accessing courts at the end, and we've got longer waits for hearings.
And I think the other thing that comes in here, and I mean, Monica and I are experiencing this right now, is the way that legal aid silos practice areas. And so often you'll have a client that has community care needs and also has housing needs. That's a really common combination. And you might have people who feel competent to do a little bit of the other, but they're primarily a housing lawyer or primarily a community care lawyer. And I'm currently working on a case, and so is Sarah, with Monica, where we actually, because there's a possession matter, and so there needs to be a housing contract, legal aid contract involved. We have two sets of solicitors working with the same cohort of clients. You're instructing us on the community care side. We've got housing folk instructing us, and that's just wild, because that adds the layers of, as well, of bureaucracy to the individuals that we're working with. They're now having to work with two sets of lawyers. I've got another case where we were exploring, you know, they weren't sure if they could do it on their certificate, what can and can't go. But they were in a legal aid desert for housing. So if they couldn't cover it, we weren't going to be able to find anyone to do it unless we went out of area. So I just think the way that we actually have our practices set up often, and that's in part dictated by the legal aid contracts, is really cuts against holistic practice for our clients when they need wraparound responses.
So after, I hope this hasn't been too doomy and gloomy. I wanted to finish with some positive things, and this might be the thing that you're actually waiting for, so apologies if it's all been a bit too doomy and gloomy, but what can we do really to support our clients to battle against all of this? So the first things are really obvious in a way, is just to understand that by the time your clients got to you, finally got a legal aid solicitor to listen to them, that they're going to want to vent for quite a long time at the beginning. So I would always just really not try and limit their venting on the first appointment too much. Just actually let them know that you're willing to listen on the first appointment. So listen to maybe some of the fringe things around their case, some of the context that might not be directly relevant, but gives you more of a context of their life and what they're going through. You probably do that already, but I know we're all really rushed. And I know we're all under pressure to try and say, focus, that's not relevant, let's deal with this. I'm here to deal with a single issue. But I think it's really important to, particularly like on the first major appointment you have with them, is to let them tell their story. Another thing I would say is to believe your client's unbelievable tales. So for example, that example I just gave you about 6 people watching a 90-year-old woman get stripped and washed for a reablement assessment. So when her daughter told me this, I thought, 6? Is that an exaggeration? That was my first response. And we've got I pushed for a safeguarding review on that, and I've got the outcome after about a year. Got the outcome of the safeguarding review, and there were 6 people. She told me there were 6, and there were 6 people, and I thought, this is unbelievable. Can't have been 6. Must be an exaggeration. There were 6. So sometimes we find out about really, really bad practice that sounds very unbelievable. We find out about it from our clients, and we're all guilty of this. We think that can't possibly be true. That's just too far-fetched to be true. And quite often it is true. Try and understand why your client may have been labelled as awkward or difficult. And it may be because actually they are awkward and difficult because that is something that they've had to do to battle over the years, you know, particularly if it's, I find it a lot with parents of disabled children, where their disabled children are now adults, you know, sort of hitting 17, 18, 19. They've got into this real battle mode, which they've had to do when they're battling education system, children's services, so many things as a child for their children, and they're still in that battle mode, and they've been doing it for so long, and they're so exhausted. And other people that they know who don't have disabled children are now being able to let go of the reins of parenting because their children have grown up and left home. And parents of disabled children are realizing, you know, young disabled adults are realizing, well, I'm going to have to battle for the rest of my grown-up child's life. And so yes, people may be awkward and difficult, but that's because that's what the system has done to them. And also, I suppose it's also about trust issues that a lot of our clients want to have a relationship. They've had a lot of broken trust in their lives, and we become somebody for them who they see as somebody maybe they want to form a bit of a kind of a therapeutic relationship with. And we have to always, under legal aid, we always have to you know, what's the word? Not knock it back, but we have to limit that, obviously. But we have to understand how, for example, you know, if we're away on leave, you know, if somebody's away on maternity leave or paternity leave and their usual solicitor isn't there, or somebody's working part-time or something, our clients get very destabilized by this, because they you know, often people who have got, you know, people with mental health issues, they've got attachment issues, and they need to feel that people are very, very reliable for them. One thing I'm very, very keen on in my practice is to make sure that your client has got agency in their own case. So involve your client, ask your client how they want to be described, let them tell their own story in their witness statement, don't just reduce them to a list of impairments. I mean, how often do we write letters where we say, you know, AB is a disabled man, he has, you know, Down syndrome, heart condition, you know, emphysema, you know, we just do that, don't we? It's so automatic for us just to start off in every letter with that list of somebody's conditions, the list of their, the medications they take. And I always think, well, if you're showing your letter, which you should be doing, obviously, to your client, how does it affect them, seeing their life reduced to a list of conditions? Disabled people have that all the time. Their lives are so medicalized. And it's really, really painful to just constantly be reading this kind of list of things about you that's kind of, you know, you may think, well, I don't really see myself as that. I see myself as a lot more than that. So I think you have to be just quite, get that balance right. I mean, it's so difficult for us as solicitors because we're trying to present our client's case at its best, at its strongest. But at the same time, we need to think about the effect that it actually has on our clients when they read these things about them, when they read a witness statement about them. I think we just need to sometimes think about, can we say something that gives more of a flavour of who they are, so that when they're reading the statement, they can see, well, yes, I'm interested in this and that. I used to work in this job. I'd like to go back to that job. I've got these family relationships. This is what my daughter means to me. This is what I want to be for my daughter. I think just to always ensure that you're making it a bit more than just this one-dimensional portrayal of your very victimy client. I think that's very important, because if your client's reading all of this correspondence, reading a case about themselves and reading their witness statement, there needs to be something in it which is kind of positive and reinforcing for them.
Can I just say something about that around agency as well? I think that particularly in possession cases where we have a client who presents with mental health problems and that's linked to antisocial behaviour, the immediate thing that as barrister I think about is I'm like, right, straight into a disability discrimination defence, let's run it. Particularly around mental health issues, but not just around mental health issues. People might not identify as being disabled. And I think as lawyers, we can forget that that's a funny thing to have as a label, and how people are going to feel about having that label applied to them. So instead of, going straight into, here's your defence, I've run the disability discrimination, this is how it works, a conversation about how they feel about that label, explaining why you're proposing that as a way forward, what the definition under the Equality Act is, and why you say they fall under that, and that, recognising that might be uncomfortable for some people, that you're saying that legally it's a good idea for me to describe you in this way, but that may not be in fact how you see or identify yourself. And I know a lot of people with mental health issues don't necessarily see themselves as disabled or want to use that label. And so again, I think it's something to be aware of. It doesn't mean you don't end up running it, but you probably want to have a conversation with the client and introduce that in a way that doesn't just say, okay, so you're disabled under the definition of the Equality Act next.
Yeah. Yeah, I think I've covered these other points as well, just trying to think in terms of the social model, thinking about what the barriers are out there to somebody achieving, what are the barriers, in a housing context, and how is that stopping them actually living their lives? What are the barriers? It's maybe just thinking to shift the emphasis just from their medical conditions onto what the social problems are. I know we're doing it, but I think we're always forced into this very, very medical, as lawyers, it's very hard to sort of square the circle when you come from this kind of, had the social model drummed into you, and then you're just presenting your clients as this list of medical conditions. And even down to things like the legal help form. How many times do I hear people start with the equality monitoring information? You don't need to start from that. You can go back to that at the end. Because if the first thing people hear about themselves is what's your ethnicity, what's your disability, it's just reducing people to boxes. Yes, it's done for good intentions because it's monitoring, it's equality monitoring, but it doesn't need to be the starting point. I would say also, always start with the person. It's quite obvious, really. Some practical things really about making reasonable adjustments in our own practice. What we do in my firm, we have a reasonable adjustment form on the file. Hopefully everybody does that. You can record at the beginning of your file what somebody's needs are in terms of their communication needs, in terms of access to the office, in terms of access to court if your case goes to court. You can also put things like their language needs and their need for interpretation on the form, although that's not, reasonable adjustment in disability sense. And check that with your client, talk it through with them, make sure that that's something you're not doing about them, but you're doing with their involvement. Ensure that your written communication is accessible. So there's nothing wrong with putting legal concepts into plain English. There's nothing wrong with it at all. You don't have to write in a fancy style. That's really, really obvious. You don't need to patronize people. But I mean, you also obviously other types of reasonable adjustments, easy read, or other communication can be used as well. Another one which I've talked to Alice about is be very, very careful of well-meaning advocates and friends and parents who try and control the case, because sometimes it takes longer to develop a relationship with a disabled client and to take instructions from a disabled client. But if it's their case, they need to be centre stage of their own case unless they don't have capacity. But even if somebody doesn't have capacity, they should still be involved and you still try and involve them to the maximum that you can. But to cut them out completely just because of time pressures is not right, and it actually leads to the wrong outcome as well.
Yeah, I'd be really, really careful on this. So I do a lot of work with disabled children and young people, and very often I'll get instructions from a solicitor or someone, and all of the instructions have come from one of the parents. And one of the first things that I ask is, have you probed at all what that relationship is and whether that is the young person or the child's view or instructions? And obviously there are often sensitivities around, there are reasons why parents are advocating for their children or carers are advocating for the people that they care for. And once you, I think, sometimes have established that that is a relationship without conflict and so on, you can, take the lead from the client about how much they want to do directly, but that needs checking. And I've definitely had cases that have come to me where I've been really, really concerned, actually, that a whole bunch of pre-action correspondence seems to be run on the say-so of not the person involved necessarily. And when you actually had a conversation with them, there are subtle but important differences. The other thing to look out for is if you've got somebody acting as a litigation friend, be really, really careful about conflicts. So I had a very difficult case where when we got the social care assessment file, it became quite apparent that the person that was acting as a litigation friend was viewed as an issue by social services. And now whether that was fair or not, because often parents are painted as an issue by social services, that obviously immediately set up a potential conflict in terms of their ability to act as a litigation friend while also defending kind of their own interests and how they're being portrayed by social services. And we had to ask them to step aside, which can be very difficult and not something that is easy to say to a parent. But it's really, really important to be very cautious, I would say, around that kind of thing, not just to ensure that you're actually keeping the person whose case it is at the center of the kind of process. Yeah.
And I mean, even if you open the case on the basis that somebody doesn't have mental capacity and you've seen some evidence that that person doesn't have mental capacity to instruct you or in the subject matter of what the case is about, you should also you should always try and ascertain that person's actual wishes and feelings and whether they're happy to have that person who's acting as their litigation friend or the quasi-litigation friend before the case has got into court, whether they're happy with that person speaking on their behalf. I think you will always need, and I think it's harder to do when we're working more remotely. I mean, we're still working more remotely than we used to before the pandemic. And it's harder to do those things. But what I always used to do is if somebody came into the office to see me, and they had somebody with them who was acting as their litigation friend or their quasi litigation friend, I would always ask the parent or the carer, whoever it was, to step out for a bit so I could have a private conversation with that person and say, you know, even if it was a really simple question like, you know, do you like that person? Are they nice to you? Do you trust them? Just to get a sense of what the relationship was. And then keep mental capacity under review during the case. You know, always check in with that person. Don't ever, even if they haven't got capacity, according to the documents that you see or according to your own assessment at the beginning of the case, check in with that person, talk to that person, and see if you can, you know, review it. You may change your mind as the case goes on.
And just on keeping mental capacity under review, if you're getting expert evidence, ask the expert if there's anything that the person could be sort of supported with to help them make capacitous decisions. So that came up this morning, which is the mental capacity legislation says that you shouldn't treat somebody as lacking capacity unless all practical steps have been taken to try to support them in their decision making. And again, I think we can be quite quick to say, frankly, sometimes it's easier to have a litigation friend for us. And so you're like, oh, phew, I don't have to navigate all of that. But you should be asking, if somebody's assessing them, what kind of support can we be putting in place? And might that help them to make a capacitous decision? And even if it won't help them to have capacity, it will still help them to participate in their own case more than perhaps they otherwise would. So worth taking that opportunity to ask the question.
That's right. I mean, in a sort of quarter protection context, you know, the person's wishes and feelings are always centre stage. You know, even if that person doesn't have capacity, it doesn't mean that they don't or that they shouldn't have a voice. So what they want is important, even if they don't have litigation capacity. What they want is still important. Language. Okay. Sorry. Just a quick one on language. So the language which we should be using about disabled people, you know, it all stems from this social model. So there's a slide here. You can look this up yourself. Obviously, we should all know we don't use terms like wheelchair bound because wheelchairs are enabling for people. People aren't tied to their wheelchairs. They are using wheelchairs to get around. There's all sorts of things which you can look up how people want to be described themselves. You can look up on the websites of organisations. Use disabled people's organisations of rather than organisations for. But there's lots and lots of places where you can look at sort of language guides. But the important thing is to check in with the person. How do they want to be described? That's a really, really key thing, because some people are kind of have got this kind of disability consciousness and some people haven't, you know, like you're saying about people with mental health issues. They may not want those, you know, they may have their own language for themselves, how they want to be described. So always check in with people. I try really, really hard not to use are we on the next slide? Language important, vulnerability. I try not to use the vulnerable word, the V word, because I just think it's meaningless, it's a cliche, it's patronizing, it comes from the wrong place. What does it actually mean? I've read bits about vulnerability theory, like I explained to you before. I think all human beings are vulnerable. That's an oversimplification. Obviously, some people have got a lot more power than others. I could tell you an anecdote about that, but I'm not going to now. About a disability organisation I worked for it was in Kensington and Chelsea, and people were speculating in very bad taste about what would have happened to Princess Diana if instead of, you know, dying, somebody wanted to write an article about this. What if she'd become one of a member of our organisation? What kind of life would she have had as a disabled person? Very bad taste. I apologise for saying that because it's quite offensive, but I think this idea of vulnerability is so linked to your economic circumstances, your economic power. So I try not to use the vulnerability word because I just think it's another thing that kind of makes people feel bad about themselves. Do people always want to be reading that they're vulnerable? You might think it's a shorthand and it helps your case. This is a highly vulnerable client. You're sending a quick email. This person's highly vulnerable. I try not to use that word personally. So, how many more slides have I got? I think that might be. Yeah. generally speaking, try, despite everything, to aim high for your clients. Just because the services are really bad out there, it doesn't mean you shouldn't be going back to those principles of the UNCRPD, thinking about what they are, thinking about what choices people should have in their lives compared to what they've actually got. Look out for spurious policies and challenge them. It may not be the main focus of your case, but if you've got a little bit of time, maybe write a letter before action, or just write a letter, or make a complaint, or see if you can refer it on to a local disability organisation if you notice something. But don't let these spurious practices or policies just go unchallenged, you know, even if it's not the core of your case. Look out for legislation and statutory guidance that may have been written in more progressive times where there was more involvement for disabled people, that was more aspirational, and try and use that because it may still be enforced, like the Autism Act guidance, for example. Think strategically. Is there something you can do strategically about an issue, particularly, like I said, if it's, well, it might be the main issue of your case, or it may be just a side issue that you notice in your case. You could try and ask the Equality and Human Rights Commission to take it up. If you notice it's a systemic problem, I've done this a number of times, refer it on to them. Are they aware of this issue? Do they want to investigate it? You know, or ask for a review under Section 44 of the Care Act, a safeguarding adult review, which is a review looking backwards. You might want to do that at the end of a case where you know something's gone very, very badly wrong. You've resolved the case, but you might want to make the local authority think long and hard about what went wrong, so that there's a published document that makes them think for the future. Finally, wouldn't it be nice if there were more disabled judges? And the way to get more disabled judges is to have more disabled colleagues, more disabled solicitors and barristers, and you can recruit people. You can even, there's no such thing as positive discrimination when it comes to recruitment for disabled people, because that's the way that the Equality Act is constructed, with reasonable adjustments. Something to think about. Listen to what disabled people and their organisations are saying about how policies are affecting them on the ground. By being aware of some of the issues out there, reading things like Disability News Service and some of these kind of news feeds, or looking at Disability Rights UK website, listening to some podcasts, looking at these amazing, I don't know if anybody's seen documentary Crip Camp, which is a fantastic history about disabled people. Just expand your knowledge, really, expand your awareness, expand your knowledge, because I think it all helps in terms of how you approach your disabled clients and in pushing for more.
Thank you, Monica. Hopefully loads of food for thought, really wonderful. I've got a couple of very short slides, and I'm mindful of time, which is such a barrister thing to say. So I'm going to have 2 slides, most of which will just point you in the direction of things about just some really practical stuff around accessibility and participation at court. If you've got a disabled client who has accessibility needs or needs reasonable adjustments before you're going to court, what can you do? And how should you be sort of integrating that? I imagine that most of you are across this. You'll know that the Find the Court Tribunal website, you can look up a court, and often the courts will have basic accessibility information on there. So whether it's wheelchair accessible, whether guide dogs are welcome, that kind of thing. It's not always accurate. So I'd say a couple of things: always get on the phone to the court as early as possible ahead of any kind of listing. We know the county court's kind of carnage and that the estate is in a poor kind of position. And so if there are going to be any issues with accessibility, you need to know about that early. The other thing I would say is that when you're talking to the court, I only know this from a colleague who's a wheelchair user, who said, don't just say, is it wheelchair accessible? And they say yes. And then you turn up and you discover that means somebody can get into the building, but they can't get into the room. Or they can get into the room, but actually the only place in the room they can get to is at the back of the room, and they're not going to be in the right place in the courtroom to actually really comfortably participate in the proceedings. So ask questions about what does that mean, and understand, don't make assumptions about your client's accessibility needs. So understand if they're a wheelchair user, how big is the wheelchair? What do they need? Let them tell you the kinds of things that they need to know so that you're able to navigate that without assumptions. If you're really going to be relying on tech provided by the court, get backups. Again, another colleague who uses a hearing loop, she always asks them to bring 2 headsets and backup batteries because the courts often don't keep these things working. Get to court really early to make sure everything's in order. Think about security checks. Sometimes your disabled clients will be carrying things that might get confiscated in security. So you just want to flag to them the kind of things that might be happening in the security check to make sure that that doesn't catch them off guard. Next slide, if that's okay. In terms of participation in the actual hearing itself, the Equal Treatment Bench book has got the most amazing content. So there's whole sections, chapter 2 on the use of intermediaries, chapter 3 on physical disability, and chapter 4 on mental disability. And there's a whole host of information there about the kinds of things and adjustments that you can ask for your client during hearing. So you want to be thinking early, again, ideally, if you're getting an expert report done, at that time, ask somebody, is this person going to need an intermediary? What of the kind of list of things that are available in sort of court as set out in the Equal Treatment Bench book and in the practice direction, which unfortunately uses the vulnerable language. That's the title of the practice direction. But would they be assisted by any of these things? And just be thinking about it in case management. Do I need to build an extra time to my time estimate for this hearing because my client is going to need breaks? Do I need to ask for a ground rules hearing? So the pre-trial review, should I get some ground rules considered there about how they might be questioned, for example, or how they're going to participate in the hearing? If you've got an intermediary, you're going to want to be lining up the intermediary to ideally attend the pre-trial review so that there can be a conversation. I'm not going to go into all of that now because we're well over time. I hope, because it's wonderful stuff, really important to hear and talk about. But there's so much information in those 2 resources. And I just think it's about thinking early. So as soon as you've got a client where you think that might be important, just getting going really early, in conversation with them about what could be done to make what is already obviously a really daunting experience in court slightly less daunting. I am really aware that we're quite behind. Sorry. So we're going to just do a couple of questions if anybody has them. Have we covered everything in the world possible? Any questions? Wonderful.
Oh, sorry. If you can hear me now. The question is the situation going back to what was, I think we were talking about at the beginning, where you have the client who is facing a hoarding injunction or possession claim, but denies they have a problem and won't engage with the medical assessment.
Yeah.
So you're then faced with an impending hearing at which you can't raise those issues. And you can't disclose any evidence that you've got because you haven't got authorization to do that. Now, my understanding is all you can do as an officer of the court is notify the court of your concerns on a confidential basis and leave it at that. But you can't sort of play God and turn up at court saying, listen, this person's not engaging.
This is one of the issues that the Civil Justice Working Group that Dan and Sophie are both on is looking at. So because we know the CPR basically picks up in part 21 from when you've got a finding somebody lacks capacity, but doesn't really tell you how to get there and if somebody won't be assessed, what you do. So they're looking at that gap. In cases where I've got a client where there are capacity concerns, but you can't take it kind of any further than that, and you're right, you don't have any kind of instructions you can act on to release confidential, highly confidential personal information, you do have an obligation to flag it to the court. It's very clear that your ethical obligation to the court requires that. In fact, you're not allowed to sit on that information. And I would often say to the other side, I have capacity concerns. I can't go any further than that, but no step in these proceedings should be occurring until that's explored. People often think that that's a strategic step to delay. There's a really helpful case. I can't remember its name. It was on appeal in relation to a litigation friend. There's a passel up on our website about it, where there was a judge who was highly critical of lawyers suggesting that capacity was being used as a strategic tool and that should never, ever be suggested. So that's useful to have in your back pocket if your opponent says that. You can, I'm hoping that the Civil Justice Working Group kind of comes out with some recommendations. You can ask the court to grasp the nettle and make a decision on capacity without medical kind of a full-blown medical assessment, I will often apply for that to be unenclosed on the basis that it's not an inter partes issue and the other side shouldn't be hearing all the sensitive evidence. That's, again, often quite controversial and not all judges like that. And so we're desperately hoping that Sophie and Dan and all of those others who are working on that working group are going to fix that lacuna for us in the CPR. But it's a very difficult thing to navigate. Really challenging. I've definitely had cases where it took us, I think we had a case where we came back to court. It took about 1.5 years to resolve the capacity issue alone, because we just couldn't really make any headway, and every county court judge we got didn't want to make the decision because they were really rightly quite nervous about it. And eventually we got somebody who normally sat in the family court and they just went, oh, and did it. So yeah.
Thank you.
Not easy. Okay. Anybody else? Are we on to the coffee and the muffins then? Well, thank you so much for coming, Monica. I think that was a really important addition to the day, and I hope everybody has taken a lot of food for thought away from that. I know I myself have taken a lot away to reflect on in my practice, so thank you.
Are disabled facilities grants and allocations. My name, for those of you who don't know me, and I think I don't know quite a few of you, I'm sorry to say, is Dave Cowan. I am an academic at Cardiff University, also an associate tenant here, and practice from here. I'll go first. Zia Nabi is going to go first to talk about allocation. Right. So I've loads of slides, but I'm going to be very, very quick. And I think a lot of this stuff you will know from either this morning or previously. So first slide is headed introduction, quite helpfully. I've spent 20 seconds saying that. Apologies. So, so the allocations are underpinned by Part 6 of the Housing Act. Okay, and there's some just very basic principles that you will all be aware of. Hopefully, that a local housing authority has got to comply with Part 6 when it allocates accommodation. A local authority has to have an allocation scheme to determine priorities. You've got a scarce resource, who gets it, who doesn't get it. You determine that by means of a scheme. What can you do about that scheme? Well, the Act says that when the local authority devises its scheme, it must frame it so that reasonable preference is given to prescribed categories of applicants, such as, for example, homeless people, people who need to move on medical grounds, people living in sanitary housing. Also, the authority can only allocate to eligible and qualifying persons. Eligibility is primarily by immigration status. Qualifying persons, well, authorities can set up their own qualification rules, such as you have to have lived in the area for 5 years, or controversially, you've got to have lived in the area for 5 years unless you're working, in which case it might only be 2, which had an impact on disabled people because they were less likely to be in work. And we'll come on to that in a moment. And what the Act makes clear is that setting those qualification criteria can't overcome the need to give specified categories of people reasonable preference. Yeah. So effectively, that basically says that again, what I've just said. But one thing to note is that in taking into account who may or may not get accommodation, you can take financial resources into account. So the millionaire applying for local authority housing is going to find things difficult. You can take behavior into account. Now that's controversial and difficult in my view, because you can disqualify people for antisocial behavior. What happens where that antisocial behavior is linked to a disability? Well, and you can also exclude people for not having a local connection. Again, controversial. What happens if you're an asylum seeker recently granted refugee status? never having been able to live anywhere in the country for 5 years, let alone the borough that you've applied to. The code of guidance, it's pretty old now, and it just says whatever, that you've got to have regard to the equalities legislation. Paragraph 3.26 says that. I always quote that. I think it's a helpful paragraph. My experience of some local authority allocation scheme has been that there's a paragraph at the end saying we've had regard to the equalities legislation, and then you sort of drill down a little bit and see what that actually means, and you're left scratching your head because it's difficult to see how the scheme itself has done what the Equality Act requires it to do. Having said all that, there's a very wide discretion. Effectively, in a case of Armad and Newham, London Borough Council, House Lord said to keen activist lawyers, hands off, don't keep troubling the courts with challenges to allocation schemes, and it's only where it's irrational that we'll be interested. Of course, Armad is 2009. Although we had a Disability Discrimination Act 2005, the Equality Act came into play in 2010, and housing lawyers caught up with it in about 2016, and we're still catching up. So yes, Ahmed says hands off, but where the Equality Act is concerned and disability is concerned, I suggest very much hands on. There we are. I think, David, you'll be happy to know I can skip this slide. And then how do you interpret an allocation scheme? Quite a basic question, quite a basic answer. But nevertheless, an important answer. The court itself can interpret what the scheme means. So adopting a common sense, non-legalistic approach. I often have cases where what is meant by an allocation scheme isn't clear, and you don't have to simply agree with the local authority's interpretation. It's an objective test. Indeed, what an allocation scheme meant came into question in the case of Noor and Birmingham. And this was a case where the first claimant, who was mum, his mum and 3 adult daughters. The second claimant was the adult daughter who had cerebral palsy with spastic dysphagia. And the family was assessed as requiring an adapted property, which in Birmingham meant effectively a house. There were no adapted properties that weren't houses. But Birmingham also had this policy that said that preference for houses with 2 or more bedrooms will be allocated to families with dependent children. So you've got this conundrum in that you've got a family with an adult disabled child who needs adapted accommodation. And you've got a policy which says, where we've got houses with 2 or more bedrooms, we'll give preference to families with dependent children, i.e. children under 18. And so what happened to Mrs. Noor, I'm going to do without this, and people can't hear me, let me know. So the council said to Mrs. Noor, you need 4-bedroom properties. You can't bid on anything other than 4-bedroom properties. The number of 4-bedroom properties was vanishingly small. So after a while, the council said, okay, then you can bid on 3-bedroom properties. So Mrs. Noor started bidding on 3-bedroom properties, and she got to bid position number 1 a number of times. And generally the way that it worked was, if you were at bid position number 1, you would be allocated that accommodation. But each time she got to bid position number 1, she was skipped. Why was she skipped? Because she was in position number 1 for a house. And Birmingham said, your client's children are all adults, and therefore she doesn't have dependent children. And those houses went to families with children under 18. And so poor Mrs. Noor was in terrible accommodation, effectively stuck. Anyway, this case went to court, and it was heard in 2 parts. Part 1 was, what does the allocation policy actually mean? And part 2 was, now we know what it means, had Birmingham been guilty of unlawful discrimination? So what the court found was that the true construction scheme was to give families with children a head start when you were being considered for a house. So it wasn't meant to be conclusive or determinative. It was just to give families with children under 18 a head start. But the way that the council was operating the scheme was treating the presence of children under 18 as determinative. That's why Mrs. Newell always lost out, because she didn't have children under 18. So that's something to bear in mind. Just because a policy says what it doesn't necessarily mean that that's how it's being applied. That's why you'll need some evidence. You'll need to go through what's happening by looking at the bidding history. So always ask yourself that question. Is what policy says, is that what's actually going on the ground? And then the court said nothing in the scheme explained what weight should be allocated to families with children in comparison to other applicants. And that was a lack of transparency, because Mrs. Newell never really knew why she lost out each time, apart from the fact that she didn't have children under 18. And the local authority had also allocated adapted housing to families with children who didn't need those adaptations. And that cut across its duty to make reasonable adjustments towards disabled people. And the court decided the authority had misunderstood its own scheme and then had then acted unlawfully in its implementation. Academic claims. These will always come up in a good allocations case, because what will happen, as happened in Mrs. Newell's case, was about 3 or 4 weeks before the final hearing was due to come on, she was allocated a house with a garden. There you are, said the local authority. We're not acting unlawfully. There's nothing wrong with our policy, but we will exercise our discretion to give you a house. Now, and because we've done that, your claim is now academic, and please can the last person to leave close the door and turn the lights off. Well, we said, or actually, I have to confess I was part of the we. We said, hang on, it's not quite academic yet, because the scheme continues to have effect for all other disabled families in Birmingham. The claimant didn't cease to have standing just because she'd been allocated a property, and the court agreed. Now, I always find Nora an interesting and useful authority to cite when you're met with an academic claim argument, because the judge said this: a public body can't avoid legitimate expectation of its lawfulness of its decision-making process by making an exception for an individual affected by that process, and then argue that the challenge should not proceed because it's rendered academic. So that's part one. So then the judge gave Birmingham a bit of time to go off and to get evidence together to deal with part two. But before we get to part two, we'll have a little break to think about what the Equality Act tells us about what sort of discrimination there is. I'm reliably told by people here that this has all been gone through. So all I want to say is 4 types of discrimination: direct discrimination, discrimination arising from disability, indirect discrimination, and discrimination by failing to make reasonable adjustments. All these are categories of potentially unlawful discrimination. And section 29 is relevant. So when you're in, it was in dispute in law, but whether allocation schemes fell under part 3, which deals with services and public functions, or whether they fell under part 4, which deals with premises. And the court said allocation schemes fall under part 3, and 29.6 and 29.7 apply. You can't do anything that constitutes discrimination, the exercise of public function, and there's a duty to make anticipatory reasonable adjustments. So the reasonable adjustment is not dependent on a request being made. The reasonable adjustment is anticipatory. Section 19, that's indirect discrimination. If I'm David, I'll just click on that. And reasonable adjustment, section 20. Just a bit of the red highlight, David will indulge me. Where a PCP of A's puts a disabled person at a substantial disadvantage in relation to relevant matter in comparison to persons who are not disabled, then A is under a duty to such steps are reasonable to have to take to avoid the disadvantage. Point to make very quickly is section 20 is a specific section in there for disabled people. So at times in the Act, you'll find that specific emphasis being put on disability. It happened in the PSED, section 149, subsection 6, happened in section 20, where there's a specific section in there which concerns disabled people. And failure to make reasonable adjustment is discrimination. Part 3 claims, I've said, means an anticipatory duty to make reasonable adjustments. What's a PCP? We don't need to think about that too deeply here. Allocations policies qualify as a relevant PCP. Case of ESOP, I'm not going to spend too much time on this, but the key thing to remember about this is don't overcomplicate it. There are things you have to show, there are things you don't have to show. So you don't have to show why the PCP puts the disabled person at a disadvantage. Why is not important. It's enough that it does. The characteristic itself need not be the reason for the less favorable treatment. All you need is a causal link between the PCP and the disadvantage suffered. The aim is to achieve a level playing field. There's no requirement that every member of the group is put at a disadvantage, and the reason for the disadvantage need not be unlawful in itself. And if you can show there's a potentially adverse impact, then you get to the first stage, and the burden then shifts to the defendant to prove that there's no discrimination on the balance of probabilities, and the court can draw adverse inferences. I put Hamlet in there because, as long as 2014, there's this case which says claims in section 29 should be brought in the county court, not in the administrative court. I haven't done one in the county court yet. They all seem to be in the administrative court. No one has cited Hamlet. Having said that, there will be cases where tactically it might be better to go into the county court, particularly if you want to cross-examine. Cross-examination is a powerful tool which is not available to you, well, only very exceptionally available to you judicially. So if you want disclosure and cross-examination of witnesses, then bearing in mind that the court under the Equality Act has the same powers as the High Court in a judicial review, you may want to consider taking proceedings in the county court. And then remedies. So allocations. I'm just going to talk about a couple of cases, and then I'm going to finish with part 2 of Mrs. Miller's case. So H and Ealing, that was a case where the council had a working households priority allocation scheme. So if you, under their scheme, if you were in work, you got a certain number of points that moved you up the list. And that discriminated against disabled people because they were less likely to be in work. And that hadn't really been taken into account when this scheme to favour people in work was being formulated. And the court said that there was a failure to comply with the PSED because there hadn't been a proper equality impact assessment at the beginning. And in particular, there was no analysis of the number of non-working disabled people who had been overtaken or at risk of being overtaken by working people lower down the same priority band. Then Ward and others against Hillingdon, which was to do with race, but nevertheless has principles which apply in all allocations cases. So the court's got to be satisfied that the allocation policy doesn't discriminate. The comparison is going to be between groups rather than individuals. And this, again, a D, it repeats what we've already heard in ESSA. But Ward and Hillingdon is useful because it applies ESSA directly into an allocation scheme context. And then in Ward, the court said, oh, the burden lies on the policymaker, on the authority to justify the impugned PCP, and it had failed to do that by the material it relied on. So in these sort of cases, you're always going to have evidence to analyze. Ask yourself, have the local authority justified the reason for any difference in treatment? And the key principle is the goal of equality of outcome. And that's a question you should be asking yourself at all discrimination cases, really. Is there equality of outcome? And if there isn't, why isn't it? Why is there not equality of outcome? And local authority relied on the discretion it had to put things right, which are called safety valves. But the court said there's no evidence that the safety valves had actually operated to eliminate the disadvantage to protected groups, and that the justification hadn't worked. Important point, compliance with public sector equality duty involves a duty of inquiry. So you can't guess everything, but once something is pointed out to you, which it was in this case by 2016, the authority ought to at least have considered the position of protected group, and its failure to do so was a breach of public sector equality duty. So if you point out something to the authority and says, this is having a discriminatory impact, and the authority does nothing, then the failure to do nothing would be breach of the PSED. And the other side of that coin is monitoring. Where a local authority has a scheme, allocations policy, a homelessness strategy, whatever, and it doesn't monitor the effect of that on disabled people, failure to carry out the monitoring is also a breach of the public sector equality duty. So NOAA Part 2. Now you'll remember that NOAA policy said preference for houses with 2 or more bedrooms will be allocated to, David's raising his eyebrows at me, and I don't think that's friendly, will be allocated to families with dependent children. So you'll remember the facts. She needed an adapted property. There was no adapted accommodation that wasn't a house. And if that meant that Mrs. was stuck, really. So how do you get over that first hurdle of showing that people with adult disabled children are going to be more adversely impacted than people with children under 18? Well, very helpfully, there was this ONS report 2020, which made the following points, which we just found by Googling, really. That disabled people are far more likely to live in social housing than non-disabled people. Disabled people aged 28, 24 and over are significantly more likely to live with their parents than non-disabled people in the same age group. And thirdly, disabled people with autism and those with severe learning difficulties are by far the most likely to live with their parents into adulthood. So if you have a disabled child, you are much more likely to have them living with you in your house after they reach the age of 18 than if you have a non-disabled child. That's just what the statistics showed. So we already know that the council had misunderstood their policy, and the judge said, well, there's no defense to say that the council said they were unaware of the discriminatory effect of the decision-making system. And he said this: disabled households could only have any chance of bidding successfully if they bid for adapted properties. Then that pool was further diminished by the rule, which gave priority for houses to households with children. That was a particular disadvantage using the language of the Act. And so it's relevant to take into account that disabled households were less likely to be able to bid successfully for houses than non-disabled households because they were less likely to have a child under 18 in their household. So although the legitimate aim to have a preference to provide houses for children, families with children under 18, the council had failed to show that this was proportionate. And the court said you've got to look at how the policy works out in practice, and there is no evidence to show that the remaining pool of properties that were available to disabled households left disabled households without children with a reasonable pool of properties they could bid for. And if the rule means there's no available accommodation for disabled families, then it's discriminatory. It's just not proportionate. And it wasn't an answer to say, and I ask you that the council retain the discretion. Often these allocation discrimination cases, the council will say, well, we've got this discretion. That suffers from lack of transparency. It's not an answer in a discrimination case, in my view. So, yeah, look on that. And then what were the adjustments that could have been made? Well, he said properties are adapted to meet the needs of disabled persons could be exempted from the automatic preference given to all houses to households with children. Or proactive steps could be taken to enable disabled people to secure other suitable accommodation other than houses, for example, by providing information about whether a non-house property was nonetheless adaptable. And he said that one of the purposes of PSED is to ensure unintended discrimination is identified before it results in individuals' protected characteristics from suffering adverse outcomes. Well, that's where monitoring is so important. If the council is not doing any monitoring, it can't show that. It will be breach of the PSED. I think in every discrimination case you have, whether it's homelessness or allocations, ask the council what monitoring are you doing? And please can you let us have a result of your monitoring? If not doing any, they are in breach of the PSE. I'm going to click on that. Now, this is a case from earlier this year. Interesting decision, and shows how it can go the other way. So, Willerton Eastbourne Council, the claimant had diagnosed ADHD and autistic spectrum disorder, and they were evicted for antisocial behaviour. And then they applied to go onto the allocations register, housing register, and they were refused entry on the grounds that you've been guilty of serious antisocial behaviour, and therefore you don't act as a qualifying person. And it was alleged that amounted to disability discrimination, and the claim failed, hasn't been appealed as far as I'm aware. What the court found was that the claimant had failed to show that the policy excluded a greater number of persons with ADHD and an autistic spectrum condition than persons without those disabilities. I have to say, arguably, that's a harsh conclusion, because how could a claimant obtain that evidence to show that? I mean, that's what the court found. But in any event, the court wasn't impressed, because the court said even if it did exclude a greater number of people, the policy was proportionate. The court also found there was no duty to make reasonable adjustments. And under Section 15 discrimination, the court said the evidence didn't show that the claimant's antisocial behaviour was a consequence of disability. Now, it's worth reading that case. It's quite a lengthy, very lengthy judgment. So I've reduced it into these bullet points. Shows you perhaps when you're doing antisocial behaviour, the court's not going to look at you as sympathetically as when you're looking at disability. And so when you're dealing with antisocial behaviour, perhaps you have to be very careful how you formulate your challenge, and very careful what evidence you have to make good your point. Finally, last slide, damages. So in Noor, the court said Mrs. Noor is entitled to damages, but she was unlawfully discriminated against. Invited the parties to agree a sum, and the court said that they'll be minor, and just you know, £5,000 damages. So £5,000 minor damages for indirect discrimination under the allocation scheme. With apologies to David for having overrun, I suspect. Thank you very much. I'll hand over to Marie.
Hopefully this will work. Hey, Z has very helpfully covered allocations. I'm going to be talking very briefly so that you guys can get away or get to drinks about physical adaptations you can make, and more specifically in this context, disability facilities grants, and a tiny little bit about reasonable adjustments. Don't worry, you've heard a lot about reasonable adjustments today, but just their relevance to disability facilities grants and some of the problems that people have getting them. So to start, this is the English Housing Survey, which is now a few years ago, but from the monitoring the government's done, the situation hasn't got any better. So it said 8% of households in England, so it's almost 2 million households, have at least one member with a long-standing physical and mental health condition. That means that they need adaptations in their home and able to enjoy the property properly and access certain rooms. 53% of households that required adaptations reported that they did not have all the adaptations that they need, and that's pretty awful. That's more than half of disabled households saying that they don't have the adaptations that they need. And alarmingly, that figure seems to be going up as the funding goes down. 25% of private renters and local authority renters who need adaptations say they have unsuitable housing. I reckon if we did a survey of people's clients in the room, that figure would be much higher. with surprisingly a smaller figure of 21% for housing association tenants, and unsurprisingly, the lowest is 17% for owner occupiers. So there's something of an imbalance there. And the returns in the survey submitted for 2019 to 20 showed that there have been 70,563 grant applications for DFGs, for disabled facilities grants. And you know, it's not a very low number that have come out of that. So out of that, there's 58,181 homes that were adapted. You don't know from that figure whether they got all the adaptations they asked for, but I mean, that's a pretty high rate of approval, I'd say. So my overriding theme for today is to say, maybe you guys know more about this than I do already, and you're doing these all the time. I think because nobody brings these challenges to me that might not be true. So if you're not thinking about making DFGs, especially in the context of so many people living in unsuitable housing, and all of us having to go through the nightmare of trying to get that through allocation schemes, or God help us through part 7, this might be something that we can think about, because sometimes a property is so unsuitable and you can't live there, but actually what needs to happen is pretty minor. So a DFG might be the solution there. There are some practical problems that we'll go into, but we have to try first of all. So what is a DFG? They're grants from a local authority. Just because it's a grant doesn't mean you don't have to pay it back. In some instances, you have to pay it back. But generally speaking, it's a grant from the local authority for disabled people who need to make adaptations in their home. And I haven't changed the slide. There we go. There's an upper limit to the grant. So there's a capital upper limit. So in England, it's 30,000. Wales are more generous, it's 36,000. Northern Ireland has a different figure as well, but I'm not sure anybody's practicing in Northern Ireland, but it is available in Northern Ireland. I think it's 26,000 in Northern Ireland. And councils have a discretion to top that figure up. So this is what they call a mandatory disabled facilities grant. It can go up to 30,000, but local authorities, again, when you say discretion, it does get a bit untransparent, as Zia said, but they do have a discretion to top up, which can be helpful. It can be paid in installments as the work progresses, or it can come to you in one lump sum. At the end of it, you normally pay it directly to the contractors. Applications are made to the local council, so they're the ones that deal with it. The money actually comes from central government when it comes to private tenants, owner occupiers, or housing association tenants. The money has to be taken out of the Housing Revenue Fund, which is already quite in demand if it's a local authority property, but that shouldn't stop them. So last year, 23-24, so this year and last year, central government gave local authorities 573 million to ring fence for DFGs, which sounds like a lot of money, and that apparently is going to stay level for 24-25. It's going to increase again the year after, supposedly. But there are real concerns about whether that money is actually going where it needs to go. So whilst it's nice to have money from central government, a lot of the problems that people may be encountering when they're applying for DFGs is, A, they don't know they exist. So it's kind of, not to be cynical, but it's kind of in the local authority's interests, the local authority having to administer all this stuff, even if they have the money, not to tell you about it, not to particularly push it. So it's not advertised. It might not be advertised in a way that people don't realize how broad it is. It can apply to almost every kind of tenure. So that's one of the reasons they make it quite difficult to apply sometimes. So local authorities have quite a lot of discretion as to how they actually deal with the applications. And then Alice and Monica were saying earlier, in reality, whilst there is a statutory time limit of 6 months to deal with the applications, they take a bit longer. But yeah, in theory, that should be a lot of money, and we should be making use out of it. There was the National Disability Strategy came out in July 2021, and they promised new guidance, which did come out in March 2022. And there was a social care white paper that also promised more funding, changes to the means test, which they say are a bit limiting, a review of grant allocations, how that works, and a new fund for minor repairs, which are quite difficult to get under a DFG. But unsurprisingly, lots of things were promised in 2021 and 2022, but as far as I know, there's been no consultation yet, so don't hold your breath. But there are solutions to those little problems that we can go into. So how are you eligible? So this comes from section 19. So, oh, and I've forgotten to change my slides. I hope you get used to it. So this is just to say, it's just so that you have the law when you get the slides. As I was saying, it can apply to almost any kind of tenure. It includes houseboats and caravans. And it actually, right at the bottom there, I believe, includes people who are licensees. Maybe it's on the next page. It is on the next page. So yeah, it's a person having a license to occupy the dwelling or flat, which satisfies such conditions as made by the Secretary of State. But that is really extremely broad. So we should, I think, be making more of these applications, at least putting that pressure on the local authority rather than this being a big pot of money that they do seem to be spending. But I think we can make better use of it, and we can maybe improve how they're doing it if we make more applications and make more complaints. So just for information, it is means tested, and there's some details about the means test there. It's really about, I mean, if your client is on universal credit or sort of passporting benefits, I think it's highly likely that they're going to be eligible, but the test is slightly different. I won't bore you with the details, but they're available there. They're from the Housing Renewal Grants regulations. If you've got a lot of capital or surplus income, then you might be in trouble. But there's all sorts of tapers and regulations there, so you have to have a look. And it might be, and is often the case, that you might be sort of excluded from getting a full grant, but you might just be expected to get contributions and you'll still have access to the fund, and that will still help you to get adaptations that you had no hope of getting before. Purpose. This is long. You don't have to read all of that. But this is, again, just to demonstrate from the Act that the sort of stated aim of DFGs and what they can be applied for is really very broad. So the next slide will give you examples. But basically, from Section 23, that's just to give you access to rooms. So specifically bathroom, family room, bedroom, kitchen. So things like widening doorways so that people with, so wheelchair users can use them. I know that we've had, I think actually, Imam may have started, Sarah will correct me if she's not here. Oh, she's gone, so I can say whatever I like. Imam started, I think, as a challenge because Miss Imam couldn't move into certain rooms because her wheelchair was too wide for the doorways, which is just an unbelievably terrible way to live. But this can help you with that, so it can help you to access rooms. There are also regulations introduced so that it can help you access a garden, which is good. More unusually, it helps you improve your heating system. And it also is there so that you can make adaptations necessary to have a carer live with you, which I think it's, we can be creative about that. So what do you actually have to prove? That comes from Section 24(3). So you'll see there, a local housing authority must satisfy itself that the works are necessary and appropriate to meet the needs of a disabled person. And so there's a two-part test, and are reasonable and practicable depending on the age and condition of the property. And it's specifically set out in the Act that in Section 24 sub 3, that the authority will consider the works are needed to provide for a care plan to be implemented, would meet as far as possible the assessed needs of the disabled person, taking into account both their physical and medical needs, distinguish between what are desirable and possible legitimate aspirations for the disabled person and what is needed. Also, further detail in Section 24(3, the decision is ultimately for the housing authority to make, but there is a duty to consult with social services on that first part of the test as to whether the works proposed are necessary and appropriate. The reasonable and practicable stuff, unfortunately, well, maybe not unfortunately, but that lies with the housing authority ultimately. But there is a duty to consult social services on necessary and appropriate, and that normally comes in the form of an occupational therapist for social services coming to tell us whether it's necessary or not. And there is a strict statutory deadline for making a decision, and that is 6 months. That may be fiction, but because it's a strict statutory deadline, you can challenge that by way of JR. So that's helpful. Whereas it's not a guideline, it's not a suggestion, it's 6 months, and 6 months is a lot of time. The decisions are challengeable on sort of ordinary public law grounds. So you'll notice in the previous slide. Oh, what have I done? I've skipped ahead. Oh, I'm going ahead, so don't look at that. Spoiling it for you. You'll notice here that it's 24(3 says the local authority must satisfy itself, which always makes me sad when I see that. So it's not for the court to decide whether factually the test is met, whether they're necessary and appropriate, whether they're reasonable and practicable. It's for the local authority to decide that in a rational way. And R. Alice Irving actually did one of the very few cases on this, which is Gulrez and Redbridge. I think everybody should read it. It's quite fun, just because Redbridge managed to make a complete meal of this test, and it gives you quite a full survey of all the ways that you can make a public law error. I think that was a test. That was a case where Alice was saying that, or Ms. Gulrez was saying that they needed a backup option for, I think it was a safety lift, because their safety lift kept on breaking. Redbridge's position was that you don't need that DFGs aren't there to help with the backup option. They can help if you fix the real one. But Alice managed to prove that they'd applied the wrong test. The fundamental principle is wrong. You can use a DFG to provide a backup function, which is really helpful, because I think lots of us see sort of shoddy adaptations that mean that if they break, people are in really desperate situations. So it's really helpful to have that backup option. Some dry stuff about the application process, but it is useful. It's quite a broad, as I said, there's not a huge amount of requirements on it. So it has to be made in writing, which is useful anyway, because you don't want to have a fight about whether the application was made. You need to specify the works that are needed. The sort of laborious bit is that you do need 2 estimates of costs of carrying out the works, and the details of any other services and charges, such as the disconnection of utilities that are necessary to get the works done. You have to do these things called an owner certificate or a tenant certificate, but they're not too difficult. They're basically just a certification of the things I've said above, and a certification that you are living in the property as your main or principal home, or if it's an owner, so for either one, that you either own the property or you have some sort of legal right over the property, so you're a tenant. Again, you should get a decision within 6 months, and once you get that decision, you should either get full details about precisely what's been approved, so how much money they're going to give you and for what, because that can change. It's not either a yes or no. They can decide to give you something similar to what you've asked for, a little less money, that sort of thing. And importantly, reasons for refusal if they do say no. You can always make a complaint to the local authority or challenge it through the ombudsman, but really your main solution to get your DFG, if you've been refused it, is to go by way of judicial review. I've been reliably informed by Alice that was under a public law contract legal aid, so that's something that we can be doing. And you don't necessarily need a housing contract or community care contract, though I think most of us probably do. And you get these things called LA top-ups, so discretionary grant. There's not a huge amount of guidance for how they're meant to use their discretion when topping up, but it is useful for things where you can't get a DFG, so a mandatory DFG. So if maybe you want to move to a new property, that's quite helpful. If you want the council to pay for a new property to be adapted, that's not necessarily going to fall under DFG, because DFGs are for where you're currently living. So that's something that you can ask the local authority to use their discretion about. And for more minor repairs, so the government has promised that they're going to think about giving a separate fund for more minor repairs that, again, can really be life-changing. But at the moment, you have to rely on the local authority to exercise their discretion. And again, it's a discretion. So if they don't exercise the discretion properly, it's judicial review. But what's the problem with it? Because I think they're not widely used, and particularly they're not widely used in the private sector. So this is from the Equality and Human Rights Commission report that was from 2018. Disabled people face particular problems in the private rented sector. Who's surprised landlords aren't particularly keen on you doing massive works at home. But the NRLA has a completely different view of landlords, unsurprisingly, and they say that 79% of landlords had no idea about DFGs. But after finding out about it, 68% of landlords were more willing to adapt their properties. And, you know, Lord knows how that question was put to them. Probably in terms of it hugely, you know, it's a sort of adaptation that every other tenant in the world will want as soon as that tenant gets evicted. But we'll take them at their word. Apparently they're keen on it if it was better advertised. But what can we do if perhaps they say no? So this is where I loop back in to reasonable adjustments, and this is about section 190. So this isn't reasonable adjustments. This applies where a tenant is a disabled person, the property is their main or only home. They must be entitled with the consent of the landlord to make improvements to the premises and must have applied for consent in writing to make a relevant improvement. A relevant improvement, I think, would cover almost everything that falls under the DFG scheme. So that's something to think about. A landlord's consent, so you can refuse. Am I all right? It's been very generous with the timing for me. With the landlord's consent. So landlord can refuse consent, unsurprisingly, but they've got to give written reasons if they do that. They can't unreasonably withhold consent. If they have unreasonably withheld it, it's taken to have been given, which is lovely. If you failed to respond to a request within a reasonable time, again, we take that to mean that you're perfectly happy with me changing your property. And it's for the landlord to prove that any consent was not unreasonably withheld. It doesn't apply to all tenancies. It doesn't apply to secure tenancies, but there are equivalent provisions under the section 97 and 98 of the 85 Act. Finally, moving to reasonable adjustments very quickly. I'm not going to go into a huge amount of detail because I think you guys are pretty fixed on reasonable adjustments now. But part 4, I think Zia and Ria's case really helpfully clarifies that we are firmly in part 4 territory with landlorded property, basically. Manager of premises. I've very helpfully highlighted the one requirement that they don't have to do, which is at the bottom. So physical features, that doesn't fall under part 35. They don't have to make an adaptation to physical feature. So how do we get around that when we're thinking about refusing consent for DFGs? That's me explaining that. They do have the first requirement, which is related to PCPs, which we've heard about already. And what we can think about is whether perhaps there's a term in the letting, so there's a term in the tenancy agreement that says that you're not allowed to have adaptations. That is, I think, straightforwardly discriminatory under Schedule 4. But if they have a general practice that's not spelled out in the tenancy agreement of refusing any sort of adaptations, is that a failure to make reasonable adjustments? Again, it's part 4. It's not an anticipatory duty you have to ask, but I think you would have asked anyway to get yourself into this position. So it's not the end of the world. So that's just a little bit more information on Schedule 4, on what a relevant matter is. And again, on the fact that you do have to make a request, but I don't think that's the end of the world. So yeah, I think we should all be applying for DFGs and challenging it when the local authority either sits on it or refuses it for silly reasons. Thanks.
Thank you, Marie. I do want to leave a little bit of time for questions. If anybody has any, we've got 2 here.
Yeah. Because they're now within the community care contract. You cannot advise on you can't help somebody get a DFG on legal help if you've got a housing contract.
You do it through the public law contract.
Sorry? But you'd need to be challenging. I don't think you can do the initial stuff of getting the surveyor's reports and getting it all together and putting in the application. You can challenge a decision not to give you one, or further down the line, you can judicially review the public law contract, but I don't think you can do the initial advice on and assistance in making the application under a public law contract.
That is a practical problem, but I think once you get to the point of a decision being made, so you're going to have people that are a bit, naturally you're going to have, it's really difficult for our sorts of clients that are really going to struggle to go about going and getting to surveyors reports and things like that. They need 2 quotations technically, but yeah, it's not something, and I don't think you'd certainly not be able to make the application on their behalf.
So in the event that someone does leave a property before the 5-year limit, what are the implications? Does the local authority try to recoup the money, or?
I will check. I'm not sure. My sensation is that they wouldn't try to recoup it. It's a question of you having to certify that you're going to stay there for 5 years. But I will check and get back to you because I actually don't know.
Just thinking, because in the private rental sector, that's
You might get.
probably
I'm sure
gonna
it will be a question
impractical.
whether it's.
Just next to you.
On the TA question, often the local authority is renting it from someone else, often a private individual. So they'll say, well, it's not our property, we can't approve you doing any work. But presumably with the section 190 refusal, you could say it's not a reasonable refusal unless they asked the private landlord. They should put the same formal request, and then they're both having to do section 190 responses effectively. Would that work?
I think that's a good idea. And also, as usual, with these horrible temporary accommodation agreements, make sure that the council is actually the landlord. Because it might be that they actually have a direct tenancy by accident with that private landlord. So there's ways around it, I think. But the bigger issue is that you've got to live there for 5 years. You have to show that you have the intention to live there for 5 years, which is quite difficult to do when technically you're on a waiting list to be moved.
Yeah, can I just say something on the getting the 2 quotes thing? Just that I've seen some local authorities, it depends on the place, where there's kind of a pre-application process where you can flag that you're interested in something and they commission maybe an OT assessment that can lead to the quotes. And so sometimes that's not legwork that's needed to be done by you. But again, it can be complicated depending on the contract. And certainly those steps might not be able to be done under the public law, but you might not necessarily need to be getting those quotes yourself. It just depends on the local authority process.
Okay, any more for any more?
I'll get back to you on the 5 years point.
I was just thinking, in terms of the private landlord thing, and if a private landlord's committed themselves to saying, well, somebody might be here 5 years, get adaptations done, and then section 21, I would be prepared to, I would have thought, well, this is an estoppel point, isn't it? If a landlord has agreed,
Don't sell the NRLA.
I'll withdraw.
No, it's a really good point. It's a really good point.
Yeah.
Just don't want to tell the landlords about it. It's our little secret. No, it didn't occur to me. It's a good point.
Okay.
Sorry, I found it. It's in the guidance, by the way, which I should have checked beforehand, about the 5-year rule. So at B34 of the most recent guidance, that's dealt with in the certificate. So you're saying that you have an intention to remain. And if that was your genuine intention, they're not going to try and recoup that money. But if they decide that you were being fraudulent, they can do all sorts.
Okay. In which case, sorry.
Rebecca.
We're talking about applications to housing authorities, and it just strikes me that where you've got a different district council and to say a situation where you've got a county council dealing with social care, what's the interplay? Can you get your care plan from your county council to say these adaptations must happen, and can you get them to support you in?
I reckon you can. Alice might have practical examples of it. So far as the law is that even if it's a housing authority and the social services authority are the same, then that consultation is not necessary. But if they're separate, then they have to have that consultation, and whether it's necessary and appropriate has to happen. So I don't see why it shouldn't form part of a care plan. Now, OTs are normally in the social services department anyway.
Okay, all right. Well, in which case I'm going to draw this session to a close, but thank you very much.
Yeah, there's a bit of a change of the programme now. What you've got in the programme documentation is, I think there's going to be a coffee break now. The bad news is that's being put off. The other bad news, or it may not be bad news, is we're not going to have the question and answer session, or the panel session. Hopefully some of the speakers are going to be around here for the reception, which we're shortly to move into. And hopefully many of you can stay for that. The good news, I hope, is that I'm going to be much less than my allotted half hour, and then we can move into the reception. I hope, as I say, you can stay for that. I just want to pick up a few themes, and one of the advantages or disadvantages of coming at this stage is that most of what needs to be said has been said, and so I'm not going to repeat things. But it seems to me there are perhaps three themes that I wanted to pick up. One was change and progressive realization, or not, perhaps, as the case may be. The second is complexity and connectedness. And the third is anticipatory duties, although you've heard quite a lot about that. Now, the first point really was illustrated and demonstrated by Clive and what you heard this afternoon. And we were reminded of the history of the development of disability discrimination law and how far we've come. And I think perhaps even a few years ago, it's hard to imagine that a conference like this would take place. It certainly wouldn't be attended by as many specialists. And the Disability Discrimination Act is, if I've got my maths right, just under 30 years old. It took until 2005 before it covered the public sector. And it's taken a great deal of time to understand and accept, if it has been accepted, the scope of what that legislation was trying to achieve, and it's still work in progress. For example, there was we can all, many of us will remember the setback with Malcolm and Lewisham, which was as recently as 2008, which took a complete wrong turn as far as many housing lawyers are concerned. And it's also taken time to take the remedial package and perhaps the power of the remedies that are available under the Equality Act seriously. Certainly in the housing field, as some of the talks this afternoon have demonstrated, the damages are still little understood. And as Sarah pointed out, judges still don't seem to accept that public law type orders can be made under the Equality Act. And so there's still a great deal of work to be done, but it's important to recognise that the progress that's been made to date. Although, as the panel discussion this afternoon pointed out, progress isn't perhaps a one-way street. The discussions touched on how far the Act is up to the task of meeting the aspirations of the UNCRPD about choice and independence and autonomy. And we heard some powerful evidence this afternoon about how far practice is turning against that, with discrimination being deeply embedded in many practices of authorities, as the presentation by Alice and Monica pointed out. And that, of course, is very difficult to address in Equality Act terms, because issues like that are difficult to get a grip on as a systemic issue. And while they can be analysed as Article 14 or PCPs that are unlawful under the Act, it's often difficult to prove that in an individual case. And it's perhaps where our procedural rules are a bit of a problem, because it may be a harder, or maybe a more powerful argument to raise that things like that can be framed as discrimination challenges, but it will often be easier simply to enforce the duty and to bring a judicial review claim without relying on discrimination. So the discrimination in that sense never gets addressed unless it's dealt with on an individual case. But as Clive showed, it's possible for a shift in thinking to make a vast difference. And I certainly found his discussion of assistive technology truly illuminating. And it was something that you very often think in terms, as Zia pointed out, that the first thing you think of when you think of DFGs, first thing you think of when you think of adaptations is physical things. But he, like all real insights, is the kind of thing where you're completely unaware of it until someone explains it and then it seems obvious. And it's got the capacity radically to change how we think about DFGs, but also about reasonable adjustments. And it may well be that assistive technology, as it develops, is going to have the capacity to blur the distinction between the three limbs in reasonable adjustments, between PCPs, between physical adaptations and auxiliary aids. And that may blunt the impact of the problematic distinction between part 3 and part 4. So we'll have to see how that develops. It'll also have an impact on the PSCD and what the menu of options is that an authority has to consider when it's addressing the PSCD, which I expect, and I haven't looked, but I expect that very few equality impact assessments address that. And it'll be interesting to see what happens in the future. Before leaving this, there's one further point about practical realization, which is that we were given a timely reminder that as representatives, we are ourselves actors in the way in which discrimination is experienced by people who are accessing services as people with disabilities. And we're given some invaluable pointers about how to combat that. Second point I want to make is about connectedness and complexity. All of the talks today were about areas which, if you'd asked me, I thought I knew fairly well. But as you drill into discrimination law, you always find more and more. And we often feel that our sessions end up being too technical, but it's unavoidable in an area like this. But one can't help feeling that there is an over-reliance on technical arguments, particularly when discrimination claims are being defended. And it's perhaps not a helpful blow-in from employment law, because the employment law becomes incredibly combative, and so much stress is given to trying to knock out or block a discrimination claim in the first instance before you get to the real issue, which ought to be proportionality. So you get arguments about what is a disadvantage, pools for indirect discrimination, burdens of proof, and so on. It's the kind of thing you don't really get in the ECHR, and it's perhaps a shame that that part, which is an inevitable part of employment law, has sort of been taken over to housing law, because one would hope, perhaps, that with more, in theory, responsible defendants or responsible respondents, one might try to get to the real issues. But anyway, the law is the law. We can't do much about it. But it does seem that there, particularly when you were talking, when Sarah was talking about Imam, and when Zia was talking about the case of Willett, that neither case really ended up addressing the real issue. The talk on capacity also showed that in dealing with this field, you've got to show an understanding of how needs are integrated. It's an understanding, you need an understanding of the Care Act, as well as court of protection, as well as housing, and how they all fit together. But there is then a problem about how they all fit together, because they're fields that have developed separately, it may well be that there's a time for an overview, because in possession actions, as Daniel pointed out, there's a binary choice, possession or not possession, and the court can in effect only grant or exercise some kind of negative control. Like, so, well, if you do this, we will grant possession. If you don't do this, we won't, and so on. COP enables a wider and more detailed approach, but they can only make an order about the available options that are put to them. And so, in other words, as long as there's been a lawful assessment, and we all know the boundaries of lawfulness, they can't make the local authority do more than that. And so what's missing is the way in which a power on the part of the court to be directly seized of what adjustments need to be made, or what needs to be done to meet the demands of reasonableness or proportionality, to direct action, for example, by the local authority if they're the landlord. And that really brings me on to the third point I wanted to make, which is about anticipatory duties. I was going to say a certain amount of that, and I had some slides, but you'll please know I'm not going to look at them because you've had enough slides, and the most of the points have already been covered. So I just wanted to just pick up a couple of points, which is that the effective realization of rights for disabled people does require public authorities in particular to be able to both anticipate need, and we've seen that some duties, like the duty of reasonable adjustments, are anticipatory in nature, at least as they apply to public authorities. But they've also got to be able to react to further information as it comes in, and we have to be able to react to that. And of course, sitting alongside the substantive Equality Act duties, there's a range of powers and duties to assess and take into account. In some ways, that's the point of Part 3, because Part 3 only is parasitic on the exercise of powers and functions. And so the discrimination aspect of the Equality Act can't change those duties. It simply means they've got to be exercised in a non-discriminatory way. But there are other powers that do perhaps give the opportunity to local authorities to carry out the sort of overall exercise that I was complaining couldn't happen in possession claims. Examples are the homelessness strategy duties in the 2002 Homelessness Act, housing allocation schemes, which of course have to meet the statutory criteria. Then there are Care Act duties, Section 2. Well, Section 1 is a wellbeing duty, and then Section 2 includes a series of duties about preventing care needs arising. And then there's also the Section 42 safeguarding duty. And then also there are duties which bring in the obligation of the local authority to act in coordination with health bodies. So the NHS Act 2006, Part A3, introduces integrated care boards, which have to have an integrated strategy. And local authorities have also got a duty under the 2006 Act to take such steps as they consider appropriate for improving the health of people in its area. And that can include providing assistance, including financial assistance, to help them minimize any risks to health arising from their accommodation or environment. That's Section 2B of the 2006 Act. And for the most part, those are, in a sense, process duties, because they require strategies to be drawn up or to take various steps, but there's little flesh on the bones. But of course, they are all duties which are going to be informed by the public sector equality duty, and the requirements that are very well known, and they've been gone through today, and I'm not going to repeat them, but you are in particular drawn attention to the fact that they include preventing discrimination, or having regard to the need to prevent discrimination and to meet the needs of disabled people that may be different from others. And so the effect is that the authority's got to address discriminatory impact of what it's doing in advance. And so in combination with the other duties, what you expect to see in the strategies is what the authority thinks it ought to be doing to address those needs. And that, of course, then has a knock-on impact in terms of justification or whether something's a reasonable adjustment. Zia pointed out that referred to the case of Gulu Ward, where Lord Justice Lewison accepted that you would have regard to what a PSED assessment did or didn't say in evaluating justification. Of course, if they have addressed something, then it's an indication about what's reasonable or proportionate. If they haven't, then it's difficult to argue that what's being proposed isn't proportionate or just or a reasonable adjustment. And at the point of relief, if the authority hasn't properly addressed the problem, then they'll need to explain how that's come about, and that may point in favour of a mandatory order being made. We get that from Imam. So these ancillary duties combined with the PSCD feed in to remedies and justification and reasonable adjustment. But it's also important to note that they have an iterative aspect, and that may be important when it comes to trying to shape what the authority is doing or what it's directing its mind to. Because although Section 21 refers to disabled persons generally, and although what that means is that, what the authority suggests, is that the local authority won't be criticised for not anticipating every group that might present. And the same applies to the public sector equality duty, I think, as Zia pointed out. But of course, some groups are going to be obvious, and the authority would be expected to anticipate particular needs that would arise there. The obvious examples might be sensory impairments. Another example given this afternoon, or this morning, I think, was ZH and the autism case and the swimming pool. But obviously there are going to be some groups who are perhaps less well known. Obviously it's going to depend on the state of knowledge at the time. In Gulu, it was the impact on refugees. And an instructive case is perhaps the one, or the FG case that Zia was involved in recently, which was a case where the claimant suffered from psychosis as a result of which she was hypersensitive to noise and smell. And the court held that it wasn't necessary to make reasonable adjustments for that group in advance because it couldn't be anticipated. But once it was drawn to the authority's attention, what the court then said was, well, although the duty applies to disabled persons generally, this is what you've now got is a class that's been identified to you that you have to take account of. And so it's for that reason I say that the duty is both anticipatory but also has to react to further information. So although it's a general duty, it can be made specific. And of course, it's our task, if our client is in a group that hasn't been referred to before, is to make it specific by simply alerting the authority to it. So those are the 3 points I wanted to pick up. I've just got 2 final points to make. One is a request, which is that please give us feedback on today's session. And there are a couple of things. One is that any ideas that should come out of this that can be taken forward. One thing, for example, that has been raised is the idea of more information about quantum on discrimination claims, which I think most people would find useful. And if you've got thoughts about how that can be taken forward, then please let us know. Or any other information that could be exchanged or any other points that could be taken forward. And the second aspect of that is that we are, I think, building now into a pattern of managing to have a conference like this every year. And it's always going to be useful to hear from you about what kind of topics you feel we should be covering. So please find time to include that in feedback if you can. Second point is thanks. And in no particular order, if I can thank the staff here at Doughty Street. Some people have been visible, but there's been a great deal behind the scenes, as I hope made this day go well and go smoothly. Secondly, I'd like to thank you for attending, still attending, and being such an attentive audience with extremely thoughtful questions where your knowledge of the area has been apparent. That's very much appreciated, and it also makes you slightly frightening. And it's for that reason my third thanks are for the speakers who've put in enormous effort and showed conspicuous knowledge and skill in presentation and given us a bit of a masterclass. It would be presumptuous for me to say that I now know everything I need to know. And if you read the title of the conference, that's not exactly what was promised. But I have learned a lot, and I hope you have as well. And I hope you'll join the reception. And finally, I hope you will join me in thanking our speakers. Thank you.